of wax today. For me, a witness. Hopefully I can help you. Yeah.
Oh, I know that because I had a case with somebody from Club Wax. Have they now installed a stage?
We don't know, but we gonna pop up today.
Don't forget, at one point it was just older, and then just.
Oh, okay. Okay. I got I brought a polo with me and some gym shoes, and he was like, "Hey, I need your suit." He was like, "If you got court, you just got court." I said, "Oh no." I said, "Look at that." So,
Simpson. Position 3 on the supplemental calendar.
Because we tried to go on a day that I didn't have court.
Do you know?
A potential trial.
He's got a W.
Investigator.
Okay, I couldn't find anything.
To be the best day.
And how about number 11 on the,
So I just told him. Comfy.
good morning. Not, okay.
Mhm.
Okay. Ms. Willingham, do you I know you remember the name. What is the name of the defendant that Mr. Johnson represents, where we're having to do another evaluation?
John Tavius, right?
Right, okay. I feel like maybe he's missed a deadline. I just need to check on that.
I think I saw something filed, but I just saw the
Okay.
defendant's name. I didn't take
Okay.
the time to look at it.
I'll look. I don't want him to miss that deadline, and if he does, then he misses it and we're ready to go. Yeah. So I will follow up on that. Morning. Thank you. All right, let's get started. Is Ms. Wood going to be joining us, or you've got everything?
Judge.
Excellent. We've got a plain arraignment calendar, a supplemental, and I think we're also, in theory, going to take a couple pleas with Ms. Taylor. I don't see her yet. So let's start. Calvin Jordan is the first two positions. He's in custody. All right.
Good afternoon. She filed waivers in all 3 cases.
Oh, he's got 3 cases.
Yeah.
All right. Look at that. 1, 2, 3. Okay.
So she's gonna be looking into drug court for him, so I don't think he needs to be brought out.
Well, I'll bring him out and just say, hey, but all we're doing is letting him know that it's a waiver. Does he know that drug court is being explored, or will that be news to him?
He said he wants drug court when it opens.
Okay, great. Can you bring Mr. Jordan to the door, please? Ms. Smith, anything you want to share about Mr. Jordan?
Yeah. Okay.
Mr. Jordan does?
Yes, it's not a necessary claim.
Well, it could be that he gets into drug court and then we have him go to Clayton to work out what he needs to work out. Hey, Mr. Jordan, how are you? I'm Judge McBurney. You have 3 cases in my division, and today was arraignment day, although Ms. Wood, who's your lawyer, filed a waiver of arraignment, just meaning she entered pleas of not guilty for you in the 3 cases. And then her colleague, Ms. Rios, shared with me that you are interested in seeing if drug court is an option. Is that accurate or not accurate?
Like a program.
Drug court is a program. It's an accountability court.
It's like, you talking about drug court, like, it's like, being in the house, like, you talking about like being in the program.
Tell me what it is you're interested in doing.
Like, also like a drug rehab program.
Okay, that's what drug court is. Drug court is a drug rehab program. You don't live there. They can help you provide housing if you need it. If you've got your own place to stay, you can stay in your own place. But it is meant for people who have been struggling with addiction for a while. And the way they explain why they're getting in trouble is because I can't hold down a job, or I got to steal to support my habit, or whatever's going on. And if that is sort of where you are in life, then drug court could be an option. And I think Ms. Wood is going to apply, which will mean someone from the accountability courts will come talk to you to see if it makes sense, if your needs are high enough and things like that. But I don't want to waste their time if you're not interested in something like that. You're interested. Okay. They're going to talk to you. There's one hiccup. I learned that you have a probation hold from Clayton County. So what we'll probably do is see if drug court is something that would work out. And then we'll obviously need to get input from the prosecutor. And if Ms. Smith says, look, if he's going to plead to these cases, we're okay with drug court, or whatever the state's view is, we'd actually get you signed up, then have you go deal with Clayton, but keep a hold on you so that when you're done with Clayton, we bring you back and get you right into drug court. Now, you got to get accepted into drug court. You and Ms. Wood will need to talk about it more. Ms. Wood will need to talk with the prosecutor, but it sounds like that's the game plan. Okay, any questions about that? All right, well, we'll see you soon. Positions 4 and 5, Ms. Smith, we will hear from Ms. Brown. She's going to hop on the Zoom. She has some adoption case she's handling in some other jurisdiction. Mr. Huey has something in some other jurisdiction because she was with him yesterday and he said, hey, I've got Fulton Court. And so she sent an email to Ms. Nelson saying, oh, I have this conflict. Is Mr. Huey in custody? Okay. And I think the way we've sorted out is that Ms. Cabrera rolled off one and Ms. Brown is taking both, even though her name is not on either one of them. So we'll come back to that when we get her on the Zoom call. Oh gosh, it's 3 cases.
And I'm sorry, Judge, for clarification, so position 5 is not gonna be Ms. Cabrera? Because that one is a DV case.
I don't think so. We need to get Ms. Brown on the call. What Ms. Nelson says is that she's handling positions 4 and 5, but now I see 6. Mr. Huey has a gun charge as well. I'm hopeful that she would take that, but I don't know that that's on her radar yet. So we'll see when she hops on the call. That gets us to number 7, Brandon Weaver in custody. I don't recognize the attorney name.
I got a call that Mr. Adams, is my understanding, is representing Mr. Weaver, and I got a call this morning that he spoke with Ms. Smith and Ms. Nelson and said he would be here by 11:30.
Mr. Adams is in Ed Adams?
Yes,
Okay,
yes.
and he'd be here by 11:30.
That's what he said.
Good to know he's making the effort. Okay. We'll come back to that one. Oh, he's got two cases. Did he tell you? Oh, because one of these is yours.
Yes.
All right. But Attorney Ganesh is with the Public Defender's Office?
Yes, I actually went to go see Mr. Weaver. He told me he hired Ed Adams.
He did. Okay. Well, that's confirmation. He will sit tight until Ed Adams joins us. Okay, then let's go to number 9. Sikamed Jawo.
I filed a waiver on this case. I do want to speak with him quickly because I do want to do a bond hearing to see if we can. I don't believe he has a bond, but double check. Let's see. He doesn't have a bond, right? Yeah, so we'll have a bond hearing if we can.
Are you prepared to talk about bond, Ms. Smith?
Yes.
Okay, and I want to be clear when I ask that, it's not like, is Ms. Smith ever ready? It's, did you know that there would be a bond hearing today? You did, okay, great. Then we'll bring Mr. Jawo out. It's a gentleman?
Yes.
Okay, we'll bring him out in a minute just to welcome and then do bond hearing.
Can I talk to him real quick?
Oh, right, you wanted to talk to him first. Yes, so let's get through the calendar and then you could talk with him and we'll figure out the order in which we're going to do things. All right, position 10, Jamal Stone. That says Cabrera. Are you Jamal Stone? You're his father. Okay, Mr. Stone. Are you Mr. Stone?
My name Corey, but I'm his dad.
What's your last name?
Corey.
Oh, Mr. Corey. All right, Mr. Corey. Is Kivante Stone related to Jamal Stone?
Yeah, they could,
Okay, so you're the uncle of Kivante?
if you want to say that.
I don't. I want to say the right thing, but you know Kivante Stone.
I mean, in family wise, yeah.
Okay,
You know what I'm saying?
but more importantly, you're the father of Jamal Stone.
Yes, sir.
Got it. Okay. So Jamal Stone says, the calendar says that's a Ms. Cabrera case and she filed a waiver. Okay. And then Kivante Stone, I think, has a bond and he's not here.
I haven't had contact with.
Okay. We will give him a chance to show up, but why don't can we bring Jamal Stone to the door, please? Mr. Stone, how you doing?
Good.
I'm Judge McBurney. Good to meet you. You are represented in your case by attorney named Ms. Cabrera, and she has filed a waiver of arraignment on your behalf, meaning she's entered a plea of not guilty for you. That means I'll be entering a scheduling order. The prosecution will get discovery, so police reports or body cam, whatever the state has. They'll get it to Ms. Cabrera and she'll come meet with you to talk about the case, to talk about how to move forward, whether that's to file motions or do something like that. But she will get with you soon. She's in another courtroom right now, so she already did her paperwork. So your case didn't have to sit around. And like I said, once she's got that discovery, she'll come meet with you. Okay? Any questions?
No, not really. I'm trying to see like blind motion and stuff like that.
So that's something to talk to Ms. Cabrera about. When she comes to see you, she's going to want to learn. She will have looked at the discovery. So she's going to say, hey, man, you're caught on video, or this doesn't even look like you. Can you tell me what was going on? You'll have a confidential conversation with her about the case. And part of that will be, hey, do we want to try to work it out right away? Should we argue for bond? Is bond a good situation for you right now? Or should we try to work the case out? Or who knows? You'll have that dialogue. And if in the end you say, you got to file a bond motion, she'll do it. I'll get you back here and we'll talk about bond. I'll hear from her. I'll hear from Ms. Smith, who's the prosecutor on your case, and let you know. But Ms. Cabrera needs to be here for that. She needs to meet you first so that she can get a sense of whether it makes more sense to push for bond now or to try to work the case out. Okay, any other questions? No? Mr. Stone, did you, or Mr. Corey, did you have a question?
I mean, they say if this, whatever going on right now, they said it don't work out. And next time tomorrow be back in court, it's in August. And you saying he got like talk his lawyer to see what's going on, like for a bond hearing, like how long would that? Could you say how long would that be?
Sure. Yeah, I don't know where you got August. We'll see Mr. Stone well before August. It's April 9th.
Yeah, no, I know what's going on. It was just saying if whatever going on today, it was like don't that happen today. They were trying to let us know that next time he'll be back in court in August. So that's why I brought that up.
Who is they? Who is saying it wouldn't be till August?
I mean, it right now, there's so many folks in town, like, we have a lawyer there, they saying he got a complete lawyer now because, so it's a lot of up and down. I'm really lost,
Okay.
Actually.
Got it. Well, I'll try to make you a little less lost. Because there are two defendants in the case, your son and Cavante Stone, the public defender initially at what's called first appearance, they represented both just to say, hey, you got a lawyer, here's what you're charged with. But they have to come off one of those cases because they can't represent both people. They may have different interests. I'm making this up, but it may be that the facts are Cavante had the gun and Jamal was just standing there saying, like, Cavante, what are you doing? You got to stop doing this. So that's a very different case for one than the other. And you don't want one lawyer handling both of those. And so the way it played out is that the public defender stayed with Cavante's case. And so we had to get a conflict defender appointed, just as good a lawyer, just handles it when there's more than one defendant. And that's Ms. Cabrera. So Ms. Cabrera has Jamal Stone's case. She will come see him as soon as she gets that discovery from Ms. Smith, who's going to make it available. And it's that time when she will talk with you, Mr. Stone, about the facts of the case, bond, schedule, things like that. Nothing is August. I'm just looking right now at the docket. So she's already filed this entry of appearance and waiver of arraignment. So your lawyer's ahead of the game. She'll get discovery now that we're having your arraignment. And then you and she will control the pace of the case. If she files a bond motion, then we get you back in here. We just have to get it on a calendar. So I'm making this up, but if she filed a bond motion at the end of next week, within a couple of weeks, we'd have you in here to talk about bond, not August. The charges are pretty serious. That doesn't mean it'll move slowly. It just means that it's a messy set of allegations. Although they're old, that's peculiar. They're 2.5 years old, but that's the kind of thing Ms. Cabrera is going to talk to you about. Like, why are we dealing with a case from 2023?
Yo, I'm so sorry, but it's so, like I said, it's so much dealing with the case, man. I can't get into it right now.
No, you shouldn't get into it right now. Yeah.
It's a lot of up and down going on with my case, and I just wanted to hear what you had to say, and I appreciate it.
You bet. Mr. Stone, any other questions?
Oh, yeah.
Not at this time. All right, we're gonna get Ms. Cabrera out to see you, and you guys will take it from there.
I do got one question. I heard that she already been put a bond motion and like she been filed a bond motion and like a bond reduction like a month ago.
In February, when you were still with the public defender, They filed a bond motion. That was before it was indicted, so that would have been heard by a different judge. Ms. Cabrera will need to file a motion for bond now that it's been assigned to a judge. But she's not shy about doing that. She just needs to come see you and talk about the case. All right, we'll see you soon. DeMarcus Greer should be in custody, not in custody? Huh. How is that? All right, 3 PI cases and he's okay.
Mark, he's not in custody. She filed a waiver of arraignment, but I think she thought he was in custody.
You.
Judge, let me clarify, I think he joined the public sessions.
I feel a little better about that. Let's see.
He just got a notification on the 11th of March. Yeah, he's down in Jackson.
Yes, there's a picture of him. Okay. So we need to track him down. He's in through February of next year at the latest. And get him, all right, in DOC custody. But you're saying, yes, so Ms. Wood did a waiver. All right, so we still need to track him down. But I'm okay that they're moving fast to get him to where he needs to be. It just didn't, okay. So Ms. Smith, we'll do a scheduling order for Mr. Greer. You can get discovery to Ms. Wood and then we'll see, it may be something he can work out virtually. All right, Floyd Boulay.
Waivers have been filed on that one too.
Okay,
My case, Judge.
it is. Let's bring Mr. Whoops. Can we bring, I don't know if it's pronounced Boulay, please. Is discovery pretty complete from the state side?
Judge, we've served everything that we have. I'm going to review again what we have and, let Ms. Wood know if there's anything else.
Okay. All right, I guess that's what I should ask. I'm confident you gave her what you had. Sometimes with these cases, they're missing pieces that you're trying to track down. Yes, please. Good morning, sir. How do you say your last name? Boulay. Mr. Boulay, I'm Judge McBurney. Your case has been assigned to my division, so I wanted to introduce myself, let you know that your lawyer, Ms. Wood, has already filed a waiver of arraignment on your behalf. That's an entry of a plea of not guilty. That gets the process moving along. I'll enter a scheduling order soon that sets some deadlines for the state to provide discovery, for your lawyer to file motions if she's going to do that. More importantly, that discovery deadline means she's going to get the evidence soon so she can come talk to you about next steps, whether that means filing a bond motion or a motion to suppress if there's something that she thinks ought to be suppressed, and coming up with a strategy about how to move your case forward. Ms. Williams, who is the prosecutor on your case, seated in the middle over at the state's table, says she's already sent most of the discovery over to Ms. Wood. So Ms. Wood ought to be over to see you soon to talk about the case and talk to you about how it's going to move forward. Any questions about any of that? Okay. She will see you soon, and then you two, you and your lawyer, will decide what's next in terms of, do we get back here for motions? Is it a case that's going to work out? Or is it something that we should get ready for trial? And Ms. Wood will let me know, okay? I'll see you soon.
And Your Honor, that concludes my business before you be excused.
Yes, ma'am.
Thank you, sir.
Good seeing you.
Good seeing you too, sir.
Raheem Smith should be in custody. And I think we're waiting for Mr. Melnick because there's a bond motion. But he also has something on the trial calendar.
You have the add-on Terrell Bond is, oh, you're talking about Mr.
Smith.
Oh,
Yeah. He's on the May trial calendar, and then he's got this new case. Okay. What are his charges in the May trial calendar?
Kidnapping, false imprisonment, assault.
And he wants a bond. Oh, one of those. Okay. All right, he's got this. We'll hold on Mr. Melnick. So let's see if, did Kivante Stone show up? Oh, all right. Ms. Smith, can we do a bench warrant for him?
Yes, Judge.
Thank you. We have a supplemental plea and arraignment calendar. Position 1 is Donovan Phillips.
Yeah, that should be good. Is he here?
He is not. All right, we'll call that in a little bit. Kiera Dickens. All right, Mickey Bateman.
Sir, he is my client. I filed a waiver. Let me just bring him to the door.
All right. Can we bring Mr. Bateman to the door, please? Deputy Gordon, you are working on, you're checking, you have confirmed or you're checking? You are gonna check. When are you gonna check? In a little bit? Okay.
You are helping.
Mr. Bateman? Good morning. I'm Judge McBurney. Your case has been assigned to my division. Your lawyer, Ms. Rios, who is seated right there, closest to you, filed a waiver of arraignment on your behalf, meaning she's entered a plea of not guilty for you. I'll be entering a scheduling order soon that will prompt the prosecution, if they haven't done it already, to get discovery to Ms. Rios so that she can then meet with you to talk about what the state's case looks like. Are there motions that should be filed? Is it something that you should try to work out or go to trial on? You guys will have your own confidential conversation about that. And then Ms. Rios will circle back with my staff to say, here's what we're doing next. Please put it on a calendar for this or that or whatever. Okay? That's where we are. Any questions about that? Okay. Ms. Rios will be out to see you soon once she gets that discovery.
Can you give a opportunity to contact probation facility or at least?
And last position is Alexandria Williams.
Judge, a waiver was filed and I believe Ms. Wood actually asked specifically for Ms. Williams to be excused for today. And if I'm not mistaken, Ms. Nelson did email back saying that was fine. But
She should sit tight.
Ms. Wood and I did speak yesterday and I expect this is probably gonna be a drug court, mental health court case.
Okay. we'll work through all that. I've asked Deputy Gordon to check on one thing, so we're gonna sit tight with that. So Ms. Williams, give me 1 minute or a couple minutes, and then we'll circle back. But thank you for being here. And then the last thing we have is Marquise Sinkfield. He's here. Excellent. What do you hear about Ms. Taylor? Great. Okay, all these people are here for you? Okay, great. And sir, you are? Did you have a case or you're here for someone else?
It's a add-on, Judge. We were here last week on Mr. Bond's case. This was the one that I needed to accuse with Mr. Melnick. So it has been accused. Ms. Nelson has the new case number and we're prepared to do a plea when Mr. Melnick gets here.
Got it. Well, Mr. Melnick is going to be here this morning. He is a man of many courtrooms, so he'll be here. And when he does, we'll work on your case. All right. So we've got a bench warrant for Donovan Phillips and Kiera Dickens. So that and a bench warrant for Kivante Stone. You, Ms. Rios, want to talk to?
Mr. Jawo, I will give you 5 minutes and I'll be ready to block.
Okay, then we'll do the bond hearing and then we'll hold on Mr. Smith because we need Mr. Melnick, Mr. Sinkfield because we need Ms. Taylor. We're waiting for a little update on Ms. Williams and I think that covers everything. Okay, why don't you go talk with Mr. Jawo?
Judge, did you receive the victim's impact statements for the case?
I did, but removing the ankle monitor or not? Yeah, I haven't read them yet.
Make sure you got it.
Yep, no, I got them. I appreciate you coordinating with them, so I could get that. I figured going slowly on that isn't an issue because it just means we maintain the status quo.
Correct.
Okay. All right, and we've got Mr. Bond's case number.
Judge, I'm ready to do the bond hearing for Mr. Jowell.
All right. Ms. Smith, you ready for that?
Yes, Judge.
Can we bring Mr. Jawo out? Thank you. Ms. Rivers, are you ready? Great. Then let's get on the record. This is 26 SC 000675, State versus, is it pronounced Jawo?
Yes, sir.
Mr. Jawo, he is here in court with his lawyer, Ms. Rios. Ms. Smith is representing the state. And Mr. Jawo, we are going to talk today about bond. Your lawyer filed a motion for bond. And it looks like right now you have no bond. So Ms. Rios is going to tell me why you should get a bond, what that bond should look like. And then Ms. Smith, the prosecutor on your case, is going to give me the state's perspective. They may agree, they may think the bond should be higher, they may think you should have no bond, and they'll tell me why, and then I'll let you know what we're going to do. Okay?
All right.
All right. Ms. Rios?
Yes, Your Honor, Mr. Jowell is 25 years old. He's born and raised in Georgia. He lives with his mother. and his father. He has one child, a 4-year-old son, that he gets 2 to 3 times a week. He also provides financial support for his child. He is also working as a pick and packer at Quick Box Fulfillment Center. He also has his GED. I don't believe he's a flight risk. He's from here. He is plans on helping to continuing to help take care of his 4-year-old child. The most that he can pay for is a $5,000 bond. Him and his family do not have much more money to post any additional bond beyond that. So I'm asking for a $5,000 bond, Your Honor.
Okay. Tell me, Mr. Jawo, this job that you had at Quick Box, what did you do there?
I'll pack like, well, I don't know the exact stuff that I'm packing actually, but I know that's all I do. I just put them inside a polyester bag and then put a shipping label on it and send it down the belt.
Got it. So you're on kind of an assembly line of something. You're putting things in a bag and it's moving along.
Yes, sir.
How long had you worked there?
Since beginning of 2025.
Oh, so for a while.
Yeah, it's been on and off.
On and off, meaning you quit and come back, or they would just need you during certain times of the season?
Yeah, certain time during the season.
How would you know when they need you to come back?
They'll send it to my phone.
Okay. And then you'd say, great, I'm coming on in.
Yeah.
This address on Hazeltine Drive, that's where your family lives?
Yes, sir.
Who is in that household besides you?
My mom, dad, and 6 other siblings.
So 7 kids, I'm calling you a kid, but 6 brothers and sisters plus you and your parents.
Yeah, it's 8 of us all together. Just 6 of them stay with my mom and dad.
Okay. And do your parents work?
Yes, sir.
What do they do?
They have their own business that they work at.
And what's that?
My mom, like, she sell clothes, and my dad, he, on and off at a warehouse.
Okay. Ms. Smith, your thoughts about Bond and Mr. Jawo?
Yes, Judge, in this case, the state will be asking for a $35,000 bond. That's based on the facts and circumstances of the case and the belief that, the defendant here is a danger to the community based on the facts of, not getting into all of the facts, but running from the police officers in the car, fleeing from the officers, hitting one of the officers' cars, and then fleeing on foot, running into someone's home by kicking into their door to try to escape, the presence of the police officers. We do want to give a bond in this case, but we will be recommending 35,000, 5,000 on each count.
Just so I understand a little bit the allegations, because it's sort of a mishmash of charges. It sounds like there was a whole lot going on January 24th of this year for Mr. Jawo. The burglary part, was that how things started, or as part of his effort to not get caught by the police, he ran into, I don't know if it's someone's house or it's a corporate entity. So I don't know if it's a business or it says a dwelling house.
Yes, a part of him trying to escape from the police officers, he went into their home.
Okay. So it wasn't that he was allegedly burglarizing a place and the police showed up and he ran. It was, he's allegedly getting away from the police in a car, then on foot, and while on foot, entered that household.
That's correct.
Okay. Got it. Are there conditions of bond that you'd want to see?
I would probably ask for home confinement. That's about it. And to stay away from the incident location or that home that was broken into.
I don't know where Hazeltine Drive is, Mr. Jawo. Is it near South Fulton?
It is in South Fulton.
It is in South Fulton.
Yes, sir.
Okay. Is it near Connolly Road?
No, sir.
Okay. All right. Ms. Rios, you want a lower bond. Are there any conditions that you think make sense in this case?
I think stay away from the incident location.
Okay. Do you have a driver's license?
I'm not sure if it's valid anymore.
Why would it not be valid?
I was supposed to go back and take the test.
Because it had expired, that you had one and then you just had it long enough, it was time to get a new one? Or did you have points on it? Why were you gonna have to go take a test?
I had it longer than I was supposed to, I guess.
So it had expired. You got a driver's license and I'll make it up.
I had it since 2020, so yeah.
Okay, it was time to get a new one.
It was
Like right now, if you were asked to show someone your driver's license, it would be an expired driver's license?
No, it wouldn't be expired, but I'm not sure if it's valid anymore. I'm not sure.
Okay. All right. Well, Mr. Jawo, I will set a bond in your case. It sounds like the state doesn't disagree with setting something, and your criminal history is pretty minor. So what I'm going to do is set a $20,000 bond through the sheriff's 10% program, which means whatever money you or your family puts up, they will get most of it back when the case is resolved. Special conditions of the bond, would you be going back to QuickBox if they have
Yes, sir.
an opening? That's the place you work, or do you have other job opportunities?
If anything, I see if I could work with the family business.
Is that your mom's business selling clothing or your dad at the warehouse?
My dad at the warehouse.
Does he own the warehouse?
He buys and sells stuff, so yeah, you could say that.
Well, I don't want to say something that's not right. So your dad has a warehouse?
Yeah, he has a warehouse.
Got it. And so you would go there to help him out?
Yes, sir.
Okay, and where's that warehouse?
I'm not sure actually.
Is it in Georgia?
Yes, it's in Georgia.
Is it kind of near Atlanta or is it in Savannah?
No, it's in Atlanta.
Okay. Do you know the name of the warehouse or his business?
No, but it's on Martin Luther King Drive somewhere.
Okay. So I'm going to put you under pretrial supervision, level 1, and done that in a minute. Is level 1 the lowest level of supervision, or is level 3 lowest? So level 1, pretrial supervision level 1. You'll be required to be gainfully employed. So that if your dad will take you in, that's great. If it's at QuickBox, that's great. But you are going to need to be home by 7 p.m. each night. So you got a curfew. You can leave the house at 6 in the morning, but you need to be back by 7 p.m.
All right.
Hopefully that won't interfere with your work hours. And you also may not drive until we sort this case out and you can show everyone what's going on with your driver's license. You need to take public transportation or have one of your many brothers or sisters or your parents get you to where you need to be. So no driving, curfew of 7 p.m. to 6 a.m., need to be gainfully employed, and the bond amount that I mentioned. Anything else, Ms. Smith, you'd want to see on the bond?
Okay, perfect. Thank you.
Okay, Ms. Rios, anything else?
No, Your Honor, thank you.
All right.
I'll call your mom.
Did you do a waiver already for Mr. Jawo? You did. Okay, so Mr. Jawo, what's next is you and your family are going to try to make the bond. If a bunch of time goes by and you can't, Ms. Rios will come back and say that bond was too high, and we'll talk about maybe lowering it. In the meantime, Ms. Rios is going to get the discovery in this case, which will probably be dash cam video and police reports.
Right.
And she'll share that with you, and start talking with you about, whether this is a case you want to take to trial or try to work out. And then she'll let my staff know when to get you back here, either from custody if you can't make bond, or, to have you come in, from home. Okay?
All right.
All right. Thanks, Ms. Rios.
Thank you. That actually concludes my business, and I need, let's just, let's say we're gonna stay or something.
Unless you need to stay for something, you can. Let me just go through this one more time. So Mr. Huey is going to be Ms. Brown. She is not online right now, so we will hold for her. We're waiting till 11:30 for Mr. Adams. Mr. Melnick is here now, so we can do the Smith bond hearing and the bond plea. And Ms. Taylor is here. I think she's right there.
Good morning, Judge.
Good morning. It's great to see you.
Good to see you, Judge.
You're on your feet. You're in court. Those are all good things.
Yes, yes.
My understanding is that there was going to be a non-negotiated plea with Mr. Sinkfield.
Yes, sir.
Okay, we can do that in just a moment if you're ready to go. I don't know if you need to speak with Ms. Smith or if you're ready.
I can speak with Ms. Smith, she's not on the mail.
She is,
She's not on bond.
so we'll do the plea. We'll do the bond plea. And so yes, Ms. Rios, that was a long way of saying you can go. Oh, wait, not quite yet. What did we learn about Ms. Williams? She's good to go. Ms. Williams, oops. Yes? Oh, that's Ms. Brown. Ms. Williams, you are good to go. There was just a concern that you might have a warrant. You don't have a warrant. That's a good development. So Ms. Wood will be in touch with you. Let me check one thing. Okay, is she on felony probation?
Is there issues now, just like.
Oh, what's the issue with probation?
It was recently issued,
Is it a not reporting, and so talking with the probation officer will help, or what were the concerns?
the basis is she was supposed to basically health eval as well as, it looks like she. Oh, this is the basis of this case as well.
Okay, all right. Ms. Williams, do you know who your probation officer is?
I don't know.
You do now. All right, is that someone you'll call when you leave here today? Please do. I have two different addresses for you. There's one on Moreland Drive and one on Valleywood Circle. Pardon me?
Valleywood Circle.
That's the better address?
Yeah.
Okay, that mail will get to you? All right. Do you have a sense, Ms. Rios, I gotta interrupt you for a sec. Did Ms. Wood indicate she's got contact information for Ms. Williams?
I believe so, I believe they spoke.
Have you spoken with Ms. Wood? That's the person who's your lawyer. You may not have met face to face, but have you texted or?
Spoke to someone on the phone, so during court today, but I didn't save the number, so.
Okay.
I'll give you her number.
Yeah, if you get Ms. Williams, Ms. Wood's number, then you call your probation officer and then save the phone number you're getting for Ms. Wood. That's your lawyer. She'll let you know what's coming next in court. She will be getting discovery from Ms. Willingham, the prosecutor sitting in front of you. And then Ms. Wood will be in a position to talk to you about what your charges are in this case. It sounds like you've got another case for which you're on probation, so you got a couple moving parts here. But just make sure you stay in touch with Ms. Wood and with probation, okay? Who did you bring with you today? Will you help Mom having Ms. Williams stay in touch with those two people?
is doing that incident. We have to go to Brady today.
Good.
Make sure she takes that from. Okay.
Yeah, so they'll give you paperwork. Don't, like you did with Ms. Wood's phone number, throw it away. Keep that paperwork. Probation's gonna wanna see that. Ma'am, do you live at the Valley Woods address as well? That's good. Okay, then we've got a good place for Ms. Williams. Mom is here. That's always a good sign. And Ms. Rios is gonna get you Ms. Wood's contact information. Once you get that, you're good to go for today. All right? So, Ms. Smith, if you'll talk with Ms. Taylor about the Sinkfield case, Mr. Melnick, I think we can do Mr. Bond's plea. You should.
And Judge, the victim is logged on, Ms. Makai Strozier.
Got it.
Yesterday when we spoke, I'm not sure she'll actually speak today, but I told her I will at the end just ask. But I don't expect her to cut her camera on unless she chooses to speak.
Got it. I see the name on the Zoom and we'll make sure to check in there. This is an accusation that will supplant the old indictment?
Yes.
So when we're done today, you'll say you're gonna null process. We'll take care of that. Okay, so we don't need to do a plea on that.
Correct.
Okay, great. Then we're gonna get on the record. This is 26 SC 001-715, State versus Mr. Bond. Mr. Bond is here with Mr. Melnick, his lawyer. We have Ms. Willingham from the state. Mr. Bond, it's my understanding you are prepared to enter a plea to this accusation that charges you with family violence, battery, simple battery, and disorderly conduct. Is that accurate?
Yes, Your Honor.
Okay. Ms. Willingham is going to put you under oath in just a moment. She will be asking you a bunch of questions about your rights, this case, and your understanding of how this is playing out. You need to answer her questions truthfully and completely. You also need to let me or Mr. Melnick know if at any point you've got questions. Will you do that?
Yes.
Okay, then let's get started.
Judge, my apologies. Can you give the new case number one more time?
I sure can.
See.
It is 26 SC 001-715.
Good morning. Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your true, correct, and legal name.
Terrell Monte Bond.
Are you at this time
Oh, yeah.
taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone in school?
46. College credits.
And are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this accusation, including any potential defenses?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes.
Have you reviewed the accusation in this case with your client?
I have.
And do you waive formal reading of that accusation?
We did.
Has your client been arrested on the original charges in this case?
Yes, he was.
And the state is unaware of any outstanding warrants related to that original indictment. Do you or your client know of any outstanding warrants related to that indictment?
I'm not aware of him.
And Mr. Bond, do you understand you're entering a plea to the following offenses? Battery, family violence, misdemeanor. simple battery, family violence, that is also a misdemeanor, and disorderly conduct, which is also a misdemeanor. Each of these charges carry a minimum of 1 day and a maximum of 12 months.
Yes.
And the state's recommendation to each of those counts would be 12 months probation to be served consecutively, so one after the other, for a total of 36 months probation. And we would be asking for you to complete family violence intervention program, have no contact with the victim, and complete 80 hours of community service.
Yes.
Okay. And do you understand that although this is a negotiated plea, should the court not accept this sentence, they can sentence you to the maximum, which would be 36 months in custody?
Yes.
And do you understand that because this is a family violence conviction, if you are found in possession with a firearm, you could be charged federally?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of this sentence?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes.
Are you on probation or parole for anything, anywhere?
No.
And are you a United States citizen?
Yes.
Do you understand that there may be adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial?
Yes.
Has anyone forced, threatened, or promised you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of battery family violence, simple battery family violence, and disorderly conduct in indictment 26 SC 001715?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in OCGA 5-6-35 and must be completed within 30 days of today.
Yes.
Do you understand that you have only 12 months from today for a misdemeanor offense to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
And Your Honor, I also stand corrected. The victim, that is not the victim in this case.
I didn't
My
think so.
apologies.
Her name was Whitney.
Yeah, you were gonna get some follow-up of it's
Yes.
Ms. Blanks,
It is
and
Ms.
I was wondering, maybe there was a name change, people can do
That's kind of
that.
what I thought too. Maybe she had,
No,
yeah.
my apologies, Judge. That is a victim in another case.
Okay.
So my apologies.
So
All right.
she's not on is what you're saying.
I do not see her on. She was made aware of today's hearing and provided with the link should she want to join.
Okay,
I had my notes. Oh, Your Honor, if this case were to proceed to trial, the state would expect to show that officers arrived at a dispute call at 4338 Schaefer Court in South Fulton County, Georgia, and they heard arguing coming from inside the residence, but no one answered the door. They then heard a woman, later identified as Miss Whitney Blanks, yell for help and stuck her head out of an upstairs window, yelling that her fiance, Terrell Bond, was not letting her leave and that she needed help. Officers also saw Bond come to the window and pull her away. Officers made forced entry at that point and saw Blanks and Bond come downstairs, Bond was detained and Blanks told officers they had been in an argument that turned physical about her infidelity. He had slapped her and choked her to the point that she could not breathe. Every time she would attempt to leave the room, Bond would physically block her, keeping her inside. Bond was Mirandized and denied the events as Blanks recounted them. Blanks had bruising under her right eye. Bond and Blanks did live together at that time. Your Honor, I've had an opportunity to speak with Miss Blanks. When she initially spoke with our office back when this incident first happened,
There are two different dates in the accusation. Was it two different incidents or
No,
that's
it was
just a
just one
typo?
that might
It's
have.
probably
do you-
typographical.
I was
Okay.
just gonna
Yeah,
say.
we'll waive any
waive
defect
any
in the.
defects. Thank you.
Okay,
Yeah, no, we don't need to come back on this case.
we don't. So it was all one incident,
It was.
exactly what you described. Argument that got physical over a perception of infidelity. Unfortunately for Mr. Bonds, some of the argument happened with where the police could see it. They bust in and do what they do.
Yes, Judge.
Okay, and what does Ms. Blanks say?
Ms. Blanks maintains now that this incident happened the way that it was reported. Back when she first spoke with our office, that was not what she stated. And as Your Honor is aware, that is not uncommon in domestic violence cases. That was actually one of her concerns. But she did state that part of the reason for doing that back then was, and I addressed it, I believe, at Mr. Bond's bond hearing. Part of her reason back then was because she just wanted the defendant's family to stop reaching out to her. She thought that that would stop it. But she does recognize that based on this charge originally came in as a battery family violence. And that was the stronger charge in the state's opinion, as opposed to the aggravated assault. And as to the false imprisonment, she does recognize that the change can not necessarily be favorable in the state's case. So with that, we decided that this was a fair resolution. She was comfortable with the fact that we were at least adding another charge. Her preference, of course, would have been for the defendant to get in custody time, but she also recognizes that he has been on an ankle monitor for quite some time, and that was part of our discussion as to why the state believed that this was a fair resolution. So although she doesn't completely agree with us, she does understand the reasoning behind why we have made this offer.
Okay, and do Ms. Blanks and Mr. Bond have any ongoing connection, kids, shared property that
Based
you're aware of?
on my conversation with her, the last time they spoke was roughly a year ago, and they have no reason to interact anymore moving forward.
Okay, so no contact doesn't create complications.
Correct.
Shouldn't create complications.
No, my client is in agreement with the no contact provision.
Great, okay, all right. What can you tell me about criminal history?
18 cycles.
18 cycles.
So it's 2026 failure to appear. 2011, unlawful for a person to purchase, possess, or control substance and sell marijuana conviction. And you got an 01 distribution of crack cocaine conviction. That's
All right, thank you. Mr. Melnick?
Thank you, Your Honor. In addition to the time that Mr. Bond has spent with this ankle monitor on since I believe July of 2024, he also spent a fairly a fair amount of time in custody. I think it was about a month or month and a half before he got a bond initially. Bond was with the ankle monitor, and then you may remember there was a bench warrant because he missed an ankle monitor compliance hearing in December of 2025 that was in front of Judge Manning. And you had agreed to set that bench warrant aside, but he still spent about 2.5 months in jail on that. So all told, he's done about 4 months in custody on these charges. He is gainfully employed, Your Honor, and as I indicated, he and Ms. Blanks have no real connection to one another other than their prior relationship. So he's in agreement with the no contact provision and will abide by that. And his main concern today is he wants for me to ensure that he can take the ankle monitor off today, which I've told him that he will be able to take the ankle monitor off today.
Okay.
Yeah.
Mr. Bond, what's your job?
I have a box truck company, owner operator, I'm sorry.
Okay. You drive a box truck or you own some and other people drive them for you?
Both.
Both.
I have a couple trucks, so I drive one and I have someone else driving the other one.
Got it. What do you typically deliver?
Just general logistics from everywhere.
Okay.
You know.
How long have you done that?
I've been in trucking since 2018. I I started driving in 2023.
Okay. And you and Ms. Blanks haven't had any communication or overlap, it sounds like, for almost a year now.
No, sir. No, Your Honor.
All right. Do you even know where she lives these days?
No, Your Honor.
Good. The ankle monitor, you will be able to get off as soon as Mr. Melnick gets you a copy of the final disposition. So I don't know that that's today. I'll sign it today and we'll get it there. But you'll need to go to Second Chance and Mr. Melnick will tell you where that is. You may already know where it is, but I just want to manage your expectations. You aren't removing it. You should not, because you're pleading guilty, go home and with cutting shears, remove it. You're just going to want to connect with the ankle monitor company with a copy of that final disposition that says case closed, and then they will take it off and they'll be happy to get their device back. You'll be even happier to have it off.
Yes, Your Honor.
All right.
Yeah.
Do you have any questions about the things we've discussed?
No, Your Honor.
Okay. Well, Mr. Bond, I find there's a factual basis for your plea. You and Ms. Blanks got into it that day in a way that I'm going to say you shouldn't have. I don't know what she said or did, but in the end, this is on you. And you're going to need to manage those kinds of relationships differently going forward. I also find that your plea is knowing and voluntary, meaning you've understood what we talked about, told me no questions, and voluntary, meaning no one's forcing you to enter this plea. Do you agree with that?
Yes, Your Honor.
Mr. Melnick, can someone in my office sign the accusation on your behalf?
Yes, Your Honor.
Ms. Willingham?
Yes, Your Honor.
And can we sign for you indicating your guilty plea to the 3 misdemeanors?
Yes, Your Honor.
We'll do that. Ms. Willingham, are you moving to null pros 25 SC 005850?
Yes, Judge.
All right, Ms. Nelson will take care of that. The jail system shows a little less time in custody. It was 75 days total. That's still a long time. I'm not minimizing it, just it wasn't quite 4 months. But I'm going to give you credit for that time in this way. Your sentences to count 1 will be 12 months to serve 2 months with the balance probated. Count 2 is going to be 12 months probated consecutive to count 1. And count 3 is 12 months probated consecutive to count 2. So it's a total of a 36-month sentence, but 2 of those months you've already done because you were in custody originally, bonded out, in again because of this ankle monitor issue. And those 2 months are backed out of the 36 of probation. So it's really going to end up being 34 months of probation. Special conditions of probation, there are 3 of them. The most important one is that you continue to have no contact with Ms. Blanks. Don't look her up, whether it's to say I'm sorry or if I ever see you again, I'm going to get you again. None at all. And if for some weird reason you guys bump into each other, just walk away. She needs to have you out of her life, and that means she's out of your life. Special condition number 2 is that you'll complete a family violence intervention program. That isn't just one class, it's a series of classes. And I'm requiring that you enroll in FVIP within the first 3 months of your probation. So it's April now. By July, you need to be in the program. Not finished it, but you need to have started the program.
Okay.
And finally, you need to complete within the first 6 months of your probation, 80 hours of community service. We're not going to wait for 2 years and then probation reaches out to me and says Bond hasn't done it. You need to do it within the first 6 months. So they'll reach out to me. If we get to November and you haven't done your community service, probation can bug me to bring you in here to say, you know what, I'm gonna actually just add more community service because you didn't do the first part you were supposed to do. So get that out of the way. By the end of this year, probation is going to be a real low-key thing. You'll have done family violence intervention program. You'll have knocked out your community service. And as long as you're staying out of trouble, probation is going to be staying out of your way. Okay?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Mr. Melnick, you and Mr. Bond need to fill out that form, and then you leave that form with me. And Ms. Nelson will get it to misdemeanor probation. And you, Mr. Bond, will get a call or an email from misdemeanor probation. This form you're filling out is your contact info. When they reach out to you, they're going to tell you how to connect with them. Do it. Don't say, I'm too busy, I can't call you, or I can't swing by. Generally, they don't require in-person meetings. They may for the very first one. The good news is, since you were able to find this building, misdemeanor probation is about a block from here. And you'll plug in with them in that way. Okay?
Yes, Your Honor.
Ms. Willingham, anything else?
Nothing from the state.
So go ahead and fill that.
Mr. Melnick, anything
No,
else?
Your Honor, thank you.
That's it. Good luck, Mr. Bond.
Judge, I'm gonna need just a moment to talk to Mr. Smith before we get started on the
Okay.
case, so if you want to take up the other one.
We will. We've got Ms. Brown on the call. Good morning, Ms. Brown.
Sorry, I think I'm on mute. Good morning.
Thank you for dialing in. You are off doing an adoption somewhere?
Yes, this is my second adoption. Well, it's my own adoption. I'm adopting a kid.
Oh my gosh, congratulations. That's great.
Yes. Yes, I adopted. This is my second adoption. I adopted, well, she's 11 now, but she was 7 at the time, a couple years ago. And then I just adopted a 3-year-old today. So,
Ooh, you're gonna have full hands. Good for
Yes.
you. That's
Yes.
so exciting. Well, thank you
Yes.
for doing that. That's wonderful for the 3-year-old and good for your growing family.
yes, yes.
Uh,
And so I'm here for Deontavius Huey.
You are, and before I bring them out, and we're just here for plea and arraignment, I want to make sure we got coverage for Mr. Huey. You and Ms. Cabrera were initially assigned an aggravated assault each, and it sounds like you've agreed to take over both those. Is that correct?
Yes, because he also has another case in front of, I think in front of Judge Whitaker. So, and I have that one too.
Okay, and he has a new case as well in front of me. And
Okay.
I wanted to know if you would be stepping in on that. It's just a possession of a firearm by a minor, so it's less serious than the aggravated assaults. But I'd love for him to be able to have all 3 of those cases moved together with the same lawyer. And we'll get you all that information if you're willing to take that one as well.
Yes, I'll handle them all.
Great. Okay, then what I'm going to suggest is we bring Mr. Huey out. He'll come up to the podium so you can see him and I guess you were with him yesterday, so he knows who you are.
Yes, I was with him yesterday and I told him that I would have his case on today. So yes, he's aware. Mhm.
Great. So if we could bring Mr. Huey, he's not here?
Come back with the key.
Oh,
He went down.
he was taking someone down? Okay. He is here. We just need to, we're locked out of our holding cells right now.
Okay.
So give us 1 second. I might say, is the adoption done or like is family in there waiting? Like, where's Miss Brown?
Yeah, I mean, so the adoption is done. Family is waiting because I have a photographer just doing all the pictures and stuff. But
Okay. All right, we'll get Deputy Gordon to move fast so we can knock this out very quickly and then you can go celebrate. What is the 3-year-old's name?
his name, well, his new name is Kason Michael Brown.
Kason Michael Brown. Great name.
Yes.
And
Yes.
he got, you said a 14-year-old sister now?
11.
11.
She's
All right, she was
Mhm.
7. She was 7 and is now 11. Great. All right.
Yes. Yes,
Is
both of them
she-
came out of foster care.
Sure. Is she excited to have a little brother?
Oh, she is very much so.
Good.
They get along very well. So I'm lucky in that regard.
Good. Well, she'll have someone to boss around, so that'll be good for her.
Well, he thinks he's the boss, so that's, just.
Oh, all right.
Of course. Yeah.
Clash of the Titans.
Yeah, he thinks he's the boss of all of us, so.
Yeah. Good.
Yeah, he's the man of the house.
Kason in charge. That's funny. Well, good. Well, Deputy Gordon is about to emerge. We'll get Mr. Huey up to the podium and move forward from there.
Okay.
Give me that accusation.
Yes.
Take your time.
9th, yes. It is 26SC 001715.
Yeah. Thank you. You bet. And then you've got a bond hearing still, great. Yeah, we all need to get back there. Deputy Gordon decided to go for a walk. I should have added as a condition of probation that Mr. Bonds take penmanship. Yikes. Mr. Who?
The cousin of,
Oh, the other defendant.
we just saw him yesterday.
Really? Huh, okay. Ms. Willingham, what case is Ms. Strozier on for?
This one.
Meaning Mr. Huey?
Yes.
Okay,
Position number 5
got it.
on that one.
Okay. What the heck? Can we have Mr. Huey? Great. Mr. Huey, come stand the podium. Right there. And you should see your lawyer, Ms. Brown, on the screen. Recognize her from yesterday. Good. Ms. Brown is handling the cases that you have in my court as well. Ms. Brown, I'm confused. Judge Whitaker has an open case, or was it a revocation matter? Because if it's an open case, we need to get them all in front of one judge.
I believe it's an open case, but it's multiple defendants. I think it's like 6 or 7 co-defendants on that case.
Okay,
I want to say it's a jail fight.
Okay, yeah, it should stay where it is. And we'll focus on these. So Mr. Huey,
We were reset for final plea for either April 28th or April 29th, I think, in there.
got it. Okay. Mr. Huey, you have 3 cases in this division.
777, I think, is the last 4 of the indictment.
Got
I
it.
believe.
Okay, we'll look for it. Mr. Huey's name is unique enough that we'll be able to find that.
Okay.
But Mr. Huey, you've got 3 cases here. 2 of them involve aggravated assault charges, and one of them is an allegation that, how old are you?
19.
Okay, the allegation is that you had a pistol when you were under 18. That's the newest one. It may be an old case, and it only recently was charged. But Ms. Brown is going to represent you on all 3. We had a little bit of a delay, no fault of yours, no fault of Ms. Brown's, but you had a lawyer appointed to represent you on one of the aggravated assaults, and then Ms. Brown to represent you on another one, and it didn't make sense for there to be multiple lawyers. One client, one lawyer always works more smoothly. And Ms. Brown very graciously agreed to handle the other aggravated assault. So this is the first time we've been able to get you and Ms. Brown all in one place. Ms. Brown, are you gonna, and we can handle the paperwork later, are you gonna waive arraignment for Mr. Huey on the 3 cases?
Yes, Judge. On one of them, I filed a waiver. The one that I think that has me listed, I filed a waiver on that one late yesterday. And then
Okay.
for all the others, I will file a waiver. Yes.
Okay, and we'll get you an email with all the case specifics on those. So, Mr. Huey, your lawyer is basically entering a plea of not guilty for you. That will trigger an obligation of the state, and you've got 2 different prosecutors because one of your aggravated assaults involves allegedly someone in your household, an intimate partner, a parent of a co-parent, something like that. So Ms. Willingham has that case, and then Ms. Smith is the prosecutor on the other 2 cases. Those lawyers will get to Ms. Brown the discovery in your cases. So police reports, witness statements, whatever the state has that makes them think, hey, this is the guy who supposedly did these things. You and Ms. Brown will look over that stuff and come up with a plan. Hey, we want to work these out. We want to go to trial, motion to suppress, motion for bond. Whatever Ms. Brown and her professional judgment decides is the right way to move forward after talking with you, she's going to do. And we'll get you back here in court to do whatever those things are. All right?
Yes, sir.
Any questions?
Yes, sir. You said I had 2 aggravated assault cases.
Yep. You want me to tell you real briefly what, like the date and the name of the people involved? See if that rings a bell?
Yes.
Okay. I don't want you to talk about them. I'm just going to tell you what the allegations are, and then you and Ms. Brown will be able to get into the details. But in one of them, case ending in 235, let's get the indictment up. You are charged with aggravated assault, and the allegation is that in May of 2024, long time ago, you committed an assault upon Janquia Brooks by threatening her with a gun, and then you had a gun. So those are the charges. Shouldn't have a gun, and then you threatened Ms. Brooks with a gun. So that's one case. The other case, and this is the one Ms. Brown has been on, I believe, all along. The allegation in the indictment is that in September of last year, so this is much more recent, you committed an assault upon Makai Strozier, she's on the call right now, by pointing a gun at her. And then again, you had a gun on you, which you're not supposed to have. And you busted Ms. Strozier's lip. And she is a parent of a child that the 2 of you have. So one involves Ms. Strozier as the supposed victim, and the other involves Ms. Brooks and is about a year older. Okay? Is that ringing a bell? Not that you did anything, but you're now understanding what your 2 sets of charges are.
Oh, yes, sir.
Okay, and then there's this newest case of all where you're charged with possessing a gun. Okay? Ms. Brown is going to get all that information together, talk with you about it, and figure out the best way to move forward.
Okay.
Any other questions?
Just on the case regarding Ms. Brooks, victim, it says something about the case was declined to prosecute.
So it may have, but it has since been indicted. Sometimes a case gets thrown out at a preliminary hearing because an officer doesn't show up. But the judge who says, I'm throwing this out, is simply saying, you're not going to be stuck in jail anymore on these charges because the officer didn't show up. The district attorney's office is always free to say, but we're going to bring an indictment, which they did. And so those charges are there. It just means that officer didn't show up at a prelim back in the day. Okay. Ms. Brown, anything else on behalf of Mr. Huey at this time?
No, Judge.
Ms. Smith or Ms. Willingham, anything from the state in the Huey cases?
Nothing from the state.
Okay, and Ms. Strozier's been listening. Did she have anything she wanted to add, or she just was listening in?
She was just listening, Judge.
Okay, all right. Ms. Brown, thank you for taking time out of what you were doing today. Congratulations again. We'll get an
Thank you, Judge.
email to you with the specifics on the other two cases so you can get waivers in those and we'll move them all together.
Thank you.
All right, take care.
Thank you.
Mr. Huey, I'll see you soon after Ms. Brown has had a chance to meet with you and talk about these cases. So, Ms. Taylor, if you are ready, we could do those please while Mr. Melnick is talking to his client. And Ms. Taylor, are you comfortable standing up at the podium or is it better to be seated at council table?
I'm okay.
Okay, great.
I believe.
If you need to pivot, just let me know and you guys can go straight to council table.
I will go to the
And you're in luck today, Ms. Smith. For whatever reason, this camera's not working, so you'll just be a voice.
So right side.
You're correct.
Okay.
Just like that.
All right.
Let me know when you're ready.
Ready, Judge?
Okay. We're going to get on the record. This is 24 SC 001279 and 25 SC 002519. Both cases are State versus Sinkfield. Mr. Sinkfield is here in court with his lawyer, Ms. Taylor. Ms. Smith is here for the state. And Mr. Sinkfield, it's my understanding that you're ready to enter pleas in both cases. Is that correct?
Sir.
Okay. Ms. Smith is going to put you under oath in just a moment and then ask you a bunch of questions about your cases and your rights. You need to answer those questions truthfully and completely. You also need to let me know, or Ms. Taylor, if you have any questions about the things we're discussing. Will you do that?
Sure.
Yes? Okay. Make sure you answer out loud. Use that outside voice so Ms. Rivers can hear you, and we'll go from there. As in, when you're ready.
I'm ready, okay. Mr. Sinkfield, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Speak up so that the court reporter can hear you.
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
I quit in one Sinkfield.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Oh, ma'am.
And is there any medication that you would normally take that you haven't been given today?
Ma'am.
How old are you and how far have you gone in school?
28 years of age, and I graduated high school with a high school diploma.
Where'd you go to high school?
At Great High School.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in these indictments?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am. I believe, certainly believe he understands proceedings, what's going on in his charges.
Do you also waive the formal reading of this indictment and any and all defects in the indictment for the purposes of this plea?
We would waive a formal reading of the indictments for purposes of the plea.
Mr. Sinkfield, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to the charges in these two indictments. Are you or your attorney aware of any outstanding warrants?
We are not.
Do you understand that this is a non-negotiated or a blind plea and that the state will recommend a sentence to the court?
Yes, ma'am.
Do you also understand that the court can impose any sentence authorized by law, including a higher sentence that is recommended by the state, up to the maximum sentence on each charge?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence? Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Ma'am.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, even on a federal case?
No.
Do you understand that if you're currently on probation or parole, that your probation or parole may be revoked based on you entering this guilty plea today?
Speak up now so that she
Yes,
can
ma'am.
hear you.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial. Do you understand that those are the rights that you're waiving by entering this guilty plea?
What now? Okay. What now? Right. Right, that's what they're saying, that by pleading, you're giving up the right to call witnesses into court for a trial.
Yeah.
So you don't want a
Yes.
trial, right?
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering a plea?
Yes.
Mr. Sinkfield, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 24 SC 001279, how do you plead to count one, possession of cocaine with the intent to distribute?
Guilty.
As to indictment number 25 SC 002519, how do you plead to count one, possession of a firearm by a convicted felon?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Mm.
Do you also understand that that process has to be completed within 30 days from today?
Ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Ma'am.
Thank you, Mr. Sinkfield. Your Honor, if this case were to proceed to trial, starting with the indictment ending in 1279, the facts would show that on July 5th, 2023, Officer Pearson, along with Officer Augustine from the Atlanta Police Department, were patrolling the area of Cortlandt Street and Baker Street. That's in Atlanta, Georgia, and also in Fulton County. While they were patrolling this area, they observed Mr. Sinkfield walking on South Cortlandt Street. The officers were aware that Mr. Sinkfield did have 2 warrants out for his arrest in Fulton County and DeKalb County. Because of that, they approached Mr. Sinkfield and detained him. At this time, the officers put him into custody after confirming that he did have those 2 warrants from Fulton County and DeKalb County. At this time, the officers searched Mr. Sinkfield after he was placed under arrest, where they found substance that was later identified by the GBI as crack cocaine, and it weighed at 3.926 grams. The officers also found $41 on his person in denominations of ones and fives inside of his pocket. And regarding that crack cocaine that was found, it was in individual baggies. Because of this, the officers concluded that that the defendant in this case may potentially be selling and charged him with possession of cocaine with the intent to distribute. Regarding the facts in the indictment ending in 2519, in this case, on April 13th, 2023, officers of the Atlanta Police Department was following up on a complaint about a narcotics-related activities that was going on in 355 Peachtree Street Northeast, that's in Atlanta, Georgia, and also Fulton County. When the officers got to that location, they saw two males involved in a hand-to-hand transaction. When the officers went to approach those two males, the only person that was still there was the defendant. The other person had walked away. However, the officers detained the defendant in this case and then eventually placed him under arrest. At this time, the officers searched his person and they found a handgun on the defendant. They ran his name through the GCIC and found that he did have previous felonies. So he was arrested for possession of a firearm by a convicted felon. And those are the facts of the case in both of the indictments we have before us. Regarding the recommendation from the state, as a global offer, the state is recommending a 10-year to serve 18 months with a balanced probated offer. Regarding the special conditions of probation, the state is recommending for the defendant to have a Fourth Amendment waiver, for him to complete an alcohol and drug abuse evaluation with treatment if necessary, for the defendant to have no drugs unless they're prescribed, for him to complete 60 community service hours, be gainfully employed, and also forfeit the monies and weapon that was seized on the defendant in the indictment ending in 2519. And also 1279. And that is all from the state, Your Honor.
All right. Thank you for that. I need to check one thing. All right. So I have some criminal history information because there's a recidivist notice. It would be helpful to know how many total cycles
15 total,
and the two most recent arrests.
2019 possession of cocaine and 10 conviction. I know the ag assault 2025.
Yeah, that's well, it's not an RC because it's a DeKalb case. I see that on the recidivist notice. That was a DeKalb conviction. Was that the most recent? It's not showing. Okay, but arrests, I know he got arrested in 23 because that's these cases. Are you showing?
I don't remember.
Okay.
Well, no, this is part of the 13 cycle.
Okay.
Yeah.
All right. Ms. Taylor.
Judge, on behalf of Mr. Saintfield, I'll address the 2021 arrest. That case is actually still pending and it's unindicted, I believe.
Well, there was one, he pled in July of 2022 to aggravated assault in DeKalb.
Okay, I'm mistaken. I'm
Okay.
mistaken.
He is still on probation? How much remains? Okay.
I got you. Okay, I'm sorry. And I misunderstood him, Judge. He was saying that is the only case that he has, he is on active probation on.
Got it.
And
Okay.
hasn't had any issues. Okay. So I misunderstood him.
That's okay.
And then the 2019 case, Judge, is, I would say actually similar to this 2024 case where he's charged with possession with intent to distribute, Judge.
His criminal history, other than the DeKalb case, is all very similar. It's simple possession, it's a gun, none of it's good, but it is in that vein of street dealing.
Right. But Judge, that's what he is actually disputed, that he was dealing in drugs. He actually is a drug user.
Okay.
And I believe in this case, in 2024, he had 3 grams. It was just in different bags. That was all he had was the drugs on him. They approached him because they said they knew him. The police said they were familiar with him and recognized that he had outstanding warrants. And when they searched him, they found the crack cocaine on him. They did not see him dealing in drugs or making any kind of transactions or anything. And he indicated to me that he was a user. He had an issue. That was in 2024. The 2023 incident, they claimed they saw people doing hand-to-hand, him and somebody doing a hand-to-hand transaction, but he denies that. Obviously, he had no drugs on him, had no money on him. He did have a handgun on him, and he made the same mistake that we know a lot of these young men make, Judge, which is the area that I be in. I felt like I needed to protect myself. I know it's wrong. I know now. Certainly not. Obviously, he hasn't been in any trouble since then, Judge. This was 23. The possession of cocaine case was in 23. The gun case was in July of. I'm sorry, April. No, July. I think of 24. So he hasn't been in any trouble since then. Has been working. I think he said he gave some paperwork to somebody here in the courtroom the last time he was here. He had been doing landscaping work. He also, Judge, helps take care of his grandfather. His family is here in court. His mom, his siblings are here in support of him. His grandfather normally comes to court with him. I've met him and talked to him several times in relation to Mr. Sinkfield cases, but he is actually in the hospital, so he's not able to be here today in support of him. So, Judge, as you heard, he's 28 years old. He'll be 29 in July. He did graduate from Grady High School, born and raised here in Atlanta. His entire family is here. And like I said, the bottom line with Mr. Sinkfield is that certainly his issues have been, I believe, with substance abuse. He's not a drug dealer. Like I said, even in that case, he had $41. And so I don't think that makes you much of a drug dealer with $41 in your pocket. And again, they did not see him doing anything wrong, just walking, and they recognized him, that there was warrants for him. The warrants from, like I said, the 2021 case. He went to DeKalb, stayed there for a while before he was brought to over here to Atlanta on the cocaine charge. He was telling me how much time he had spent over there, but I told him that you can't get credit for that time in DeKalb, even though you had this Fulton County hold warrants on you, waiting or whatever. So, Judge, again, he is accepting responsibility and it's trying to make amends. Again, he has stayed out of trouble. He's been on the probation on the case out of DeKalb, so he is on probation on that case. And certainly I've been very concerned about these two cases. And having to leave, not certainly wanting to leave his family, wanting to continue on the road to recovery and doing what he's supposed to do. And they are certainly in support of that. And like I said, he's managed to not get in any trouble since July of 24. Judge, I am asking the court to consider the sentence the court that the state is asking for, but with the deviation that it be reduced to time served. He's already served, I think, about 3 or 4 months, Judge, on these cases prior to making bond. And even with increasing the conditions, certainly he understands no drugs, no alcohol. He would have to have an alcohol and drug evaluation. So he's not opposed to any of that. He welcomes that. Community service, they're recommending 60 hours. I'd ask the court to consider, if you're considering what we're asking for, which is to give him time served on for this case and probation, increase the community service hours, increase the time, certainly knowing that he's on probation for 10 years, even if it's no early termination of the probation, He's willing to do that because he wants to be able to remain with his family, continue the road to recovery. He's very concerned about his grandfather and being able to help his grandfather. And like I said, continue on the road that he's been on, Judge. That's what we're asking the court to consider. He knows having a gun was wrong. He certainly would never do that again. Hasn't had a gun since then. That was in 2023, the gun charge. So that's been now April. Matter of fact, that's now been 3 years ago for that case. So we'd ask the court to consider our request to give him time served and probation in this case.
Got it. Mr. Sinkfield, I've got some questions for you. Do you have questions for me?
I'm not sure, sir.
You're not sure whether you have a question for the judge?
Oh, no.
No?
Okay,
Okay.
No,
all
sir,
right,
no, sir.
all right.
All right. Question one. How's your grandfather doing?
I'm really skeptical about getting to the hospital right now because I don't want him to see me and go on and die off. That's the main reason why I haven't been there to see him yet. But as my family said, he's doing not he's not
doing
good.
well.
Yeah.
Okay, I'm sorry to hear that. Do you have kids?
No, sir.
What job do you have now?
Right now I work with Malcolm Brothers and LLCs, and it's a landscaping business. I'm also into like other gigs and Craigslist jobs. I'm not sure if you're familiar with or anybody familiar with Craigslist gigs.
Tell me what that, I've heard of Craigslist. What do you do through Craigslist gigs?
It's like various gigs that people post for help, for side jobs, for quick money,
Got
things
it.
of that nature.
Mhm.
But
So it's not like, hey, I'm gonna go do this for 6 years, but someone would say, we're tearing down this wall, could you come help? Or we're moving these boxes, or
Yeah.
we need to do something, and you say yes, you show up, you help, you get paid.
yes, I'm on that heavy.
And then you're doing this landscaping work.
Yes, yeah.
And
Is
how
that,
long you been working with the Balcom Brothers Landscaping LLC?
It's been like 2 or 3 years now.
Okay, and then on the Craigslist, just like the judge was indicating, what types of jobs do you get with the
Like
Craigslist?
maintenance field, landscaping, whatever they post.
Just like what he
art
said,
labor.
it could be tearing down a building or picking up, because he was telling me they was cleaning up scrap from some buildings or something, that kind of thing.
If
Okay.
they say pull up, shove a boulder with your head, I'll do it if I can.
All right.
You know what I mean?
shove a boulder with your head. How do you get around? Do you have a driver's license?
Yes, I do have a driver license, but I sometimes use MARTA, and if I get up enough, I rent a car.
Okay.
Get from point A to B.
Got it.
I ask my mother, and my sister to haul me.
Okay.
And
All those people back there are relatives of yours or friends of yours?
My mom right there, my
Yeah.
2 little sisters right there, to the right of her, and my brother in the middle. That's his friend. I call all them my brothers.
Okay. So that's close friends and family, and they're here for you.
One is a friend, the rest of one is his brother, the other 2 are his sisters and his mom.
I got it. Who lives in your household? All these people?
No. I go to my mom's house from time to time, but I'm currently living with my grandma.
You're living with your grandma?
Yes.
Okay.
That's where you.
But sometimes you stay at your mom's?
Yeah. They help
Okay.
with those.
Who stays with your grandma besides you?
No one but my granddad.
Okay, and is this the granddad who's in the hospital right now? Do any of your other siblings, brothers or sisters, help take care of your grandmother?
Yes. That one right there, Candasia, him too.
Okay.
If he
All right, they help you out, help her out. Okay. Are you the oldest, the youngest, in between?
I'm the oldest.
You're the oldest. Okay. All right. You were arrested in July of 23 for the second of these two cases. I'm gonna call it the cocaine case. You went to jail for a while here. You were in the Fulton County Jail for almost 3 months. Then you went to DeKalb. How long were you in the DeKalb County Jail?
And all, I counted like 9, 10 months, I think, almost a year.
So you were over in DeKalb for a long time.
Yeah.
What was going on there? Was that related? Was it a probation revocation?
No, yeah.
Okay.
It was these cases,
It was related to this aggravated assault case that you were there for,
the probation on that.
or the
Yeah.
probation?
Ms. Simpson, what do you have in your system about time Mr. Sinkfield served in connection with that revocation?
He had a hearing, in December of 23.
Mm-hmm.
He was revoked 9 months. The judge gave him credit because he was with us first in July. He received credit from July up to the date of the revocation as Thompson.
Got it. Okay. So when was he, do you have a release date from DeKalb? Would that be in your system?
It's not in mine, but I can get it from the jail law.
That's impressive. You can't get it?
It's showing.
He would have gone in September of 23.
He went in September 23, was released, excuse me, April 1st of 24.
All right. So it's 9 months. Okay. The range, Ms. Smith, for the case ending in 279, the drug case is what?
10 to 40.
Got it. Okay.
And for purposes of the plea will be withdrawn the recidivist knowledge.
Thank you. I had to ask that. I meant to ask that. I didn't get there yet. Thank you. So Mr. Sinkfield, anything else you want to share with me?
I'm pretty sure I shared the letter,
You did?
and you know the things I've been doing, man. I've been on the straight and narrow. I'm working hard. Like I said, I help keep my little ones level headed, and you know what I mean, keep them on the straight and narrow. My little brother, he play basketball, and later on tonight, he got a
Where does he play basketball?
Doug High School, and
The season's over now.
yes, but
Okay.
they still playing.
Oh, sure, you gotta be.
He got a visit in college, Harvard and Boston. He leaves tonight. And
Someone here is going,
yeah,
you're going up to Cambridge?
Boston, Massachusetts, for a Harvard visit.
Basketball is recruiting you?
No, I'm going for academic action, but
Okay,
dealing with basketball.
got it. And you're at Douglas High School?
Yes, sir.
All right.
and that other one, there's China. She's in hair school, I think, and she, Candasia right there. She works at a local gym. I think is it yeah, the city of Atlanta, and you know I just keep them level headed and try to drive them to be better than me, and the best, really.
What do you think changed for you? Because you, for a while, were out in the streets and would have been a very bad role model for each of those. But now you seem to be doing a lot better. And I'm trying to figure out, is that who you are today? Because you're in here saying, Judge, you got to be nice to me, or it's who you are now, as in going forward, Mr. Sinkfield isn't that guy who was getting arrested with drugs and guns. What changed? You grow up,
You get to a certain point to where it's just like, I done missed all my birthdays. Incarcerated. And I mean, the only birthday I made was my 23rd birthday, and it's just like, you get tired, and you just want to.
It's time to change.
Yeah, it ain't me, it ain't me. Like that jail, that going to prison, man, it burnt out. You know what I mean? And it ain't making me no better. But it's to make you or break you. But going to the system, it's just like you able to, like you see too much stuff to where it's like it's trouble. It's easy to get into. You know what I mean?
Yep.
And
no, I had a guy in here the other day, older than you, say, Judge, he needed more help than you need. He needed to get into some kind of treatment program. He said, I can just walk down certain streets and I get in trouble. All I have to do is start walking down the street and I'm going to get in trouble. This was a guy in his 40s, but he knew, like, if I'm in the wrong place, it's just too easy. I'm going to steal something, or I'm going to smoke something, or I'm going to buy a gun, and he says, all I have to do is walk down the street, Judge, and it's going to happen. And it seems like when you were younger, that was you. Yeah. That you walked down the street and, man, it didn't matter. You had something in your pocket you shouldn't, or you're with someone you shouldn't be, and boom, you're on the ground, you're in the back of the squad car, and you're away from your family.
And
why should I be confident that that's not happening to you anymore?
Okay, I'm confident.
You're confident. Okay.
It's in my head every time I wake up. You know what I mean? Every time I go to my mom's house and see my little brother running around, and they doing their thing, and see my little sister, and see my other sister pull up. She having cars and things of that nature, and she got her own apartment. And
look what can happen, right?
That nature, and I'm the oldest,
right?
So
you got a little brother who may go to Harvard,
right. And it's just like, nah, man.
Okay.
My little sister is really she on her stuff, but me keep going to jail and keep in and out of prison and things of that nature, and I can't even get my stuff right. You know what I mean? I can't even get myself together.
Well, it sounds like you're starting to get yourself together, which is good.
And what you told me was that this, I believe Judge, he actually got arrested in the same kind of area, the Cortlandt Street in this other area. He don't go to, like you said, he don't go to those streets where you go get in trouble. He doesn't go to those places anymore, is what you're telling me.
Well, that helps. That helps.
Yeah, they help. They told me to stay away from the Imperial. I don't go by the Imperial. Of course, the hotel's there, but every time I look toward that street, I'm hauling as away.
Good. Okay. I'm glad you're getting away. Mr. Sinkfield, I find that there's a factual basis for both your pleas. These are situations that happened a long time ago, and you have clearly traveled a great distance since then. I don't mean that you went to California. I mean, you've grown up, and you seem to care more about the things that matter, which would be family and having a job so you can help take care of people. That's great. I hope it sticks. It seems like it has, because these are all a while ago. We're in 26, and these were back in 23. And since then, there hadn't been more. Now, granted, you were out of commission for a big chunk of that time because of your revocation, but it sounds like 25 went pretty smoothly, and you were there for your family in a way that as the oldest you ought to be. So anyway, I do find that in July of 23, you had the drugs, and in April of 23, you had the gun. You can't ever have a gun again. Don't have one in your household. If there's one in your grandma's household, you need to get it out because that's your household. If there's one in your mom's household, it needs to get out because you can't be around one. If the police, for whatever reason, are coming, maybe there's a 911 call because your grandmother's fallen down and they're there and they're trying to help everyone. They see a gun, that's going to be on you. And as a convicted felon, it's going to stick like Velcro and you're going to jail again. So if you feel a need to protect yourself, protect your family, baseball bat, bow and arrow, axe, no guns. If you and I are having a conversation about you having a gun while you're on probation in these cases, I'll have that conversation and Ms. Taylor can try to work her magic, but you're going to prison. You got to be away from the guns. Not because I'm worried you're going to go shoot someone, just you're done with them. And it's too dangerous to be around guns. Someone sees you with the gun and they're going, I'm going to shoot first. And so that's something that you can't have anymore. Pretend you're allergic to them. I also find that your plea is knowing and voluntary. Knowing means you've understood what we talked about. And when you didn't, you asked Ms. Taylor. She said some things to you and you said, okay, I get it. Do you feel like you understand what we discussed? All right. Voluntary just means no one's forcing you to enter these pleas. Do you agree with that?
Yes, sir.
Okay. Ms. Taylor, can someone in my office sign, actually, they're both accusations, not indictments, doesn't really matter. But can we sign the 2 accusations for you?
Yes, Judge.
Ms. Smith?
Yes, Judge.
And Mr. Sinkfield, can we sign your name to the 2 accusations indicating you're guilty, please?
Yes, sir.
All right. So, Mr. Sinkfield, by my math, you did at least 9 months in custody. So here's how I'm going to sentence you. On the case ending in 279, I'm going to sentence you to 10 years to serve 9 months with the balance on probation. I am going to add as a special condition of probation, however, that you will spend 10 consecutive weekends, starting not this weekend, but next weekend in jail. You're going to check yourself in Friday in the evening. You get out Sunday in the evening, but we're skipping 1 weekend. It's going to be 10 weekends, but we're skipping the weekend of July 31st. You're going to be with your family for your birthday. All right? Those 10 weekends are the last time you're ever going to be in jail. They're going to be a reminder of the dumb things you used to do and the value of the good things you have now. Your family, your job, all that kind of stuff. It's not going to be fun. You've been there, but it's just weekends. You turn yourself in Friday, you get out on Sunday, you can be working during the week. And like I said, we're going to pass over the weekend of July 31 and have that 10th weekend just be 1 week further in. Other special conditions of probation. There'll be a 4th Amendment waiver. I'm going to have you submit to a drug and alcohol abuse evaluation. That's just you meeting with a counselor who's going to talk to you to see if there is any ongoing concern about you drinking too much or using something you shouldn't use. And if that person recommends treatment, that treatment is part of your probation. Going to NA meetings or AA meetings, and then it may not be an issue, but I'm seeing you right now. I'm not seeing you on weekend nights or whatnot. So I don't know what you put in your system. I do know that if you're putting the wrong thing in your system, it's going to be harder for you to do what you tell me you want to do, which is be there for your family and hold down a job. So if what Ms. Taylor says is accurate, that you were more a user than a seller back in the day, let's just make sure that you don't have any issue in terms of an addiction that someone needs to treat. If they need to treat it, that'll be part of your probation. You'll need to complete 60 hours of community service, and you'll need to do that during the first 6 months of your probation. So get that out of the way early on. And you will forfeit whatever was seized from you in that case from July. Your sentence in the case ending in 519, that's what I'm calling the gun case, is the same. So it's going to be 10 years to serve 9 months with a balance on probation. And you're going to have those 10 weekends in jail, not starting this weekend, but it'll be starting on Friday the 17th. So that's next Friday. You turn yourself in by 5 o'clock. And you go straight to the jail like you're going to visit someone, and they're gonna know you're coming, and they'll process you, check you in, and you'll be out by Sunday at 5 o'clock. Again, you'll skip the weekend, that is your birthday weekend. And then all the other things, Fourth Amendment waiver, the drug abuse evaluation, community service, and you'll forfeit the gun that was seized from you. Those are all the same. The last thing I'm gonna do, Mr. Sinkfield, is set what's called a behavioral incentive date. And so on April 10th of 2029, that's 3 years from now, if you have done all the things you're supposed to do on probation, which I think you will have done by the end of this year, and more importantly, you have stayed out of trouble, probation can say to me, hey, let's close this case out. Sinkfield has been doing what he needs to do. He's 31 years old now. Maybe he's a dad, he's working. Can we not have to spend 7 more years looking over this guy's shoulder? And I'll say yes. But if you've been goofing off and letting your family down, then you got 7 more years of probation. So you've got an incentive to do the things that you have been doing and keep doing them. And I hope you do. Ms. Smith, anything else in connection with Mr. Sinkfield's cases?
Nothing further, thank you.
Ms. Taylor?
Nothing else from us, Judge.
All right.
Sinkfield understands that he has to turn himself in by 5 o'clock on Friday, the 17th. That's his first weekend.
Right, next Friday.
and
And you're gonna do that every weekend for 10 weeks, except you're skipping your birthday.
Weekend.
And then I don't know how many more weeks it is after that. It's gonna be spelled out in your sentencing document. You'll know. Make sure someone gets you there. Don't be late. Don't skip a weekend. Know this, if on Friday, whatever it is, something real bad, say your grandfather passes, call Miss Taylor. She'll call my chambers and we'll postpone that weekend. If an emergency arises and you say, I can't go this weekend because I got to be with my family, my grandfather passed, we'll move that weekend to the end of the list. What you shouldn't do is skip the weekend because it happened and then call and say, oh, by the way, I skipped the weekend because I stubbed my toe. You need to ask in advance, not let us know afterwards, because probation will reach out to me saying, hey, he didn't show up this weekend. Here we go. The Mr. Sinkfield in court is not the Mr. Sinkfield in real life.
And Judge, if I could, by your saying that for the record, indicate that if you can't get in contact with me, then you need to contact probation and the emergencies that the judge has indicated.
Right. You should have a probation officer already.
Right.
You live in Fulton County?
I stand.
Your grandma's home is what county?
DeKalb.
Okay, so you're gonna keep the same probation officer. Ms. Simpson, who is with probation, is gonna give you reporting instructions for these 2 cases. 1 officer for all your cases.
That's gonna be the probation officer.
And so it'll probably be the same one, but you may have to, and Ms. Simpson's gonna tell you this, you may have to report to the Fulton office the first time for these cases because they're Fulton cases. I don't know how that works, but she's gonna talk to you once we're done, okay? Are you guys gonna make sure he doesn't screw this up? Good. All right. Hey, good luck in Boston. All right. See you guys.
All right, thank you, Judge. That's all I had to make the excuse.
Yes.
Sinkfield knows he has to talk to probation.
So we've got Mr. Smith's bond hearing. Is that it? And then in theory, Ed Adams shows up in 14 minutes.
So, sorry, we didn't really get a chance to talk about this. Big one.
Right, I mean, we didn't even want to finish, and we got in contact with him. Yeah. And even else, my victim actually reached out to him. I didn't reach out to him because he was supposed to think that he let him have such a but she won't need now.
Monday.
Has the same recollection of what happened in the police report? And he's opposed to the rated or just how?
Sure.
Right.
All right, Ms. Rivers, are you ready?
Yes.
Okay, we're gonna get on the record in State versus Raheem Smith. It's 26 SC 001 009. Good morning, Mr. Smith.
Morning, you one.
Mr. Smith is here with his lawyer, Mr. Melnick, and then Assistant DA Smith, a different Smith, is here for the state. Mr. Smith, we're going to talk a little bit about bond in your new case. I was just looking, I had a note here. You've got an older case that's coming up on the trial calendar soon. So I'm going to need to understand how this interacts with that. Mr. Melnick fortunately represents you in both cases, so he is in a position to say, here's what's going on with the two cases. But we're going to talk about bond. Your lawyer filed the bond motion a while ago, and we are here to hear it. I just need to look at one more thing. Well, that's interesting. The alleged victim in this case is a co-defendant in the other case. Complicated world we live in. Give me one more second so I get your new case back up on the screen. So you've got no bond in this case.
That's correct.
So Mr. Melnick, tell me your thoughts about this situation.
So let me just kind of start with some basic information. Mr. Smith is 29 years of age. He has lived in Atlanta for about 6 years. He's originally from the U.S. Virgin Islands, but he and his sister live here in the Atlanta area. He is gainfully employed. He works. He's got a cleaning company that does residential and commercial cleaning. So he has strong ties to the community. His mother and sister have been very heavily involved in helping him through this process.
And his sister is not a defendant in the bigger case?
No.
Okay.
Different sister.
A sister
There
is
a sister, but it's a
okay,
different
not the one who has been particularly helpful here.
Yeah.
Okay.
So, Your Honor, with regard to this case, as you can see, the alleged victim is Tyrone Patterson, who is also a co-defendant in the older, I'll just refer to it as the older case because I only have the case number for the new case here. So the incident happened on August the 9th of 2025. The alleged incident happened on August the 9th of 2025. Mr. Patterson actually did not speak with the police that day or any time thereafter, as far as I know. It was his girlfriend who claimed that Mr.
Patterson's girlfriend.
Mr. Patterson's girlfriend
Okay.
claimed that Mr. Smith and Mr. Patterson got into an altercation that involved a knife.
Is Mr. Patterson's girlfriend a defendant?
Not that I'm aware of.
Okay.
So obviously this creates, from my view, a difficult scenario for the state in that their witness would have to be, I mean, their victim would have to be a co-defendant in a case that they are prosecuting, actively prosecuting right now. Mr. Patterson is represented by Ms. Rios, and I asked her if the state had been in touch with her about communicating with her client. about the situation, and she told me no. She was not even really aware of it until today. At Ms. Rios, I should say, when I say she was not aware. Ms. Rios was not aware of it until today.
Sure. It's all very new. I mean, this indictment isn't even a month old, so
Right.
the lack of awareness to me isn't surprising yet.
Well, but that's good. The incident itself was alleged to have happened on August the 9th of last year. We've had court at least once, maybe twice since then, on the older case, and obviously Mr. Smith has been here, and there hadn't been any issues between himself and Mr. Patterson. I'm not aware of any subsequent issues between Mr. Smith and Mr. Patterson since this incident is alleged to have taken place. I have not had a chance to review the discovery in the case, Your Honor, so all I've really had a chance to do is read the warrants and the police report. But given the totality of the circumstances, I mean, Mr. Patterson is fine. He was here in court. Mr. Smith was here in court. They were in court together. There wasn't an issue.
It was the day before. Plea and arraignment for Mr. Smith. And I don't know if Mr. Patterson was there. People have kind of trickled in the older case, but plea and arraignment for the older case for Mr. Smith was August 8th. And August 9th is this alleged situation.
I think Patterson was arrested before Mr. Smith was, because you're right. This case has been through a couple of different iterations.
Yeah.
I probably waived arraignment. I did. I filed a waiver of arraignment on August the 7th. So Mr. Smith may not have even been here, but we were here there was a motions hearing on November the 14th. I don't know if we had to come for that or not.
You didn't.
And then we had
final plea was on
December 16th.
Right.
So we were on that January 7th trial calendar, but we didn't actually report for that.
No, Mr. Adams had a conflict, Keith Adams.
Keith Adams
And
did.
so we had to take it off that calendar.
Came in January 7th.
We did come on January 7th?
Yeah, we came in January.
Okay,
Yeah.
great. It's just we weren't able to reach it because of that conflict.
So in any event, Your Honor, I say all that to say that obviously Mr. Smith is presumed to be innocent on these new charges. The incident itself is now over 6 months old. Mr. Smith has appeared in court at every time that he's been ordered to appear in court for the older case, so there doesn't seem to be any evidence or inclination that he's a flight risk or that he's not going to show up in court when ordered to do so. There's no evidence that Mr. Smith would, in any effort, try to intimidate Mr. Patterson. They've been together, and as I said, Ms. Rios has no awareness of all of this taking place. And given the unique totality of all of these circumstances, Mr. Smith has been in jail now since February the 17th, so going on 60 days. I recognize that he's out on bond for the other case and he's arrested, and oftentimes that's a trigger for either revoking a bond or not granting a bond. But I think this is a unique set of circumstances, and I'm asking you to grant a reasonable bond in this case. So one thing I did check, and you may be looking for this now, as to whether his old bond had a condition of no contact with any co-defendants. I did not see that. I don't want to say with absolute certainty, but I don't believe there's any condition of no contact with any co-defendant. But I do believe that that is a reasonable condition to place, to have no contact with, at least with Mr. Patterson, or I would say any other co-defendant other than Mr. Smith's blood relative, who's a co-defendant on the 25 SC case. Mr. Smith has indicated that he is willing to comply with any other terms and conditions that you would deem to be appropriate, including an ankle monitor, if you think that's appropriate for this case, Judge.
All right. I'm looking at the bond in the other case.
I believe the only condition was that he's to have no contact with the alleged victim in that case, Judge. And the other standard conditions.
Oh, that's not, this was Judge Wolf denying bond.
So I think we did a consent bond
there
on
we
May
go.
7th
Yep.
of 2025.
Yep. Yep.
No contact with
Jason
Soldrich?
Soldrich.
Yeah.
That's it. That's not Mr. Patterson.
That's correct.
Okay. All right. Got it. Ms. Smith, peculiar set of circumstances, but we do have Mr. Smith out on bond, and it's always a condition of bond not to get in trouble. And he got that bond in May of 25, and then fast forward to August of 25, and there's this incident.
Yes, Judge. In this case, the state will be asking for no bond to be set for various reasons, starting with the state's belief that the defendant is likely to reoffend. The defendant currently has, based on my reading of his GCIC, 3 open cases for violent acts. This case that we're talking about here today, of course, the other case from 2025 is on our May trial calendar, where the defendant is accused of aggravated assault, 2 counts, kidnapping, false imprisonment, battery, and possession of a firearm during the commission of a crime. And then also this other open case in East Point for battery from this year. So these 3 cases that the defendant has pending and open, the state does believe that there is a likelihood of the defendant to reoffend and may reoffend in a violent way against another person. Also regarding witness intimidation, the state does believe that the defendant in this case is likely to intimidate the witness. The DA's office was able to speak with Tyrone Patterson. I did not speak with him personally since he is co-defendant on the other case, Ms. Carla Martinez. They were able to speak with Mr. Patterson, who said that.
Ms. Martinez, is she a victim advocate? Is she okay?
She spoke with Tyrone Patterson, who told her that he was stabbed 8 times. What happened to him was traumatic. He lost his job, he lost his car. His whole life changed after this event, and that he is opposed to bond and concerned because the defendant knows where he lives. Mr. Patterson and the defendant, they run in the same circle, they know the same people. So the state does believe that there is a high likelihood that the defendant in this case would and could intimidate the witness. Overall, based on the facts and circumstances of the case, these 3 open cases that the defendant has, and the likelihood of him intimidating the witness, the state is going to ask for no bond to be set in this case.
Are you in a position to give a thumbnail sketch of Mr. Smith's supposed role in the older case? A whole bunch of people are indicted, and nothing wrong with that, but sometimes someone is indicted as party to a crime, but that person's role was he watched the door for police. Important, but different from he hit the person with a 2x4.
From my understanding, Your Honor, he was one of the people who met the victim at the door, brought him into the home and assisted with the beating or fighting of the victim. Took a cigarette butt as accused, putting it on the defendant, hitting him with a pole, and just being around the other co-defendants. I don't know if his role in that case is as big as the other co-defendants. However, the role that he did play was taking the victim from outside of the home inside and participating in the aggravated assault against him.
Okay. That's your current best understanding of how if something went down, how it went down.
Yes.
Okay, thank you. Mr. Melnick, final word
Thank you, Your
from the defense.
So I will say, as it relates to the older case, Judge, there are a lot of problems with that case. And it's probably too much for me to get into right now, but
I'll just always remember Mr. Adams saying, I look forward to this trial, and no one disagreed with him on the defense side.
I think it's going to be a difficult state for the case, difficult case for the state. I'm sorry, Judge. Judge, with regard to the East Point arrest, that case was accused, 26 CR 001078, assigned to Judge Richardson in state court and was null pros yesterday. So that is obviously a disposition in Mr. Smith's favor, and I would ask that you regard that accordingly.
Can you give me the number again?
26 CR.
Yep.
001078, and then there's an F as in Frank on the end of that.
Yeah. So, what I'm reading is that the state announced it was unable to proceed, and then Judge Richardson dismissed it. So, that's a little, I mean, I appreciate no process and dismissal. It doesn't look like you were counsel for him. Ms. McLeod was. Do you have any information of, well, boy, we really wanted to go forward, but the victim won't talk to us? Or it could be a little murkier than, yes, it was dismissed. I don't dispute that. It's gone. It's closed.
So it also, the dismissal order does say that the record can be restricted, which the failure to, if I remember correctly, the failure of a witness to appear or to be cooperative would ordinarily not result in the case being eligible for expungement. In other words, if the state were to say there's probable cause to continue prosecuting this case, but we're just unable to do so because of the unavailability of a witness, ordinarily that would not be a case that would.
They wouldn't restrict it.
That's correct.
Got it. That's a good distinction.
Your Honor, with regard to the argument related to possible intimidation of witnesses, we're 6-7 months out from 8 months out from this incident, and they've been in court a couple of times together. There's no evidence that there's been any effort to intimidate Mr. Patterson. So I don't believe that that is a valid concern. If there is any argument in that regard, I do think that putting Mr. Smith on an ankle monitor would satisfy that concern. So that's what I'm asking you to do.
Got it. Okay. Mr. Smith, at this time, I'm going to deny bond. We will keep talking about this. And more importantly, Mr. Melnick is going to get the discovery in the case, and he'll have an opportunity to get back in front of me with you to revisit this question of bond if the case ends up being something other than what the state has described, what I read in the affidavit that the detective took out for your arrest. There are some moving parts. There's some complexities to it. At this point, I'm not comfortable setting a bond, not because I think you'd disappear. I want to make that clear. It's not risk of flight, so we don't need to get back together for you to bring in more information about risk of flight. It is more safety of the community. Would something like this happen again? I appreciate the state court case has been dismissed, but we've got the open case, and now these allegations. And these are different from the open case where who knows who did what. This is a very specific set of allegations. And I think we ought to be able to get to the bottom of this one much sooner and directly than in that other case. So for now, I'm leaving the case in a no bond status, but I'm very open to revisiting it after Mr. Melnick gets a chance to dive into the discovery in this case. And he may have very good reason to say, we need to talk some more. And we'll take it from there.
Thank you,
Okay?
Judge.
You're welcome.
Thank you so much, Your Honor.
You're very welcome. Before you both go, I just want to make sure in this case so that it moves maybe more rapidly than the older case. We're also on for plea and arraignment. Are you waiving arraignment?
Yes, Your Honor.
So you'll fill out a form, leave it with me before you leave? Okay. Mr. Smith doesn't need to stick around for that. He's entering a not guilty plea for you. That'll get him the discovery in the case, and you guys will go from there.
Thank you so much, Your Honor.
You bet.
Can you tell me the indictment number? Do you have it right there?
Okay. 6-001-009. Yep.
Here he is. Judge, Matt Burke.
Yes, sir.
Thank you.
Thank you. Appreciate it. Hello, Mr. Adams.
Boy, how you doing?
I am well. Why don't you talk for a moment with Ms. Smith? You are here, I believe, for Brandon Weaver.
Right.
Great. He's got 2 cases on for plea and arraignment.
Weaver's a custody.
Yeah, he's in custody. You know what? You got you.
Yes.
If a person takes a plea and the state decides to withdraw the recidivist notice, does that also affect that person being reviewed by the repeat offender council?
I'm not sure I know what the repeat offender council is.
Well, I guess the whomever, because I know Officer Calhoun has this whole repeat offender.
Oh, the repeat offender commission.
Yes.
2 different things. Repeat offender commission always uses as its benchmark the number of convictions you have. And if you have 3 or more, you hit their radar. You are labeled as a repeat offender. That has no legal effect. It has a procedural effect. It's flagged in the DA's office. They're supposed to treat it differently. It's tracked by the repeat offender commission. But it is the repeat offender label. There's a flag that is there in Odyssey, is meant to alert people to the fact that that person is a repeat offender, so that maybe when you're thinking about a disposition, you think about it differently than if this was this person's first offense. But the thing that actually has teeth is the recidivist notice. And if the state withdraws it, then you could have 1,000 convictions. And I may sentence you a little longer because you're on conviction number 999, but you are parole eligible. All the things that being a recidivist, if you're sentenced as one, that locks in, are not locked in. And so it's typically a bargaining tool for the state, unless there's trial. If there's trial, they leave it in place. But for a plea, they often withdraw. But not always. You've seen Ms. Smith say, nope, we're not withdrawing it there. And that way, if the state doesn't, they may ask for 3 and the judge says 2, it's still 2 to serve and you're not going to get paroled. But if the notice is withdrawn, then you are parole eligible. I don't have to sentence to the maximum, all those things. You will be less parole eligible if you have a whole bunch of convictions, but still eligible. So they might consider you after 27 months instead of 21 months because, gosh, this is his 8th conviction. But you'll still be considered, and especially if it is another entering auto, and a judge says, I'm sentencing you to 5 years to serve. If it's not a recidivist sentence, you're gonna get paroled out, even if it's your 20th. I mean, those beds are precious here in our jail, but also at the Department of Corrections.
Yeah, I was looking at issue, that's what made me ask, if
At whose criminal history?
Mr. St. Phil's.
Yeah.
I was wondering if that made a difference, because I saw at one point he was, his case in our system was reviewed by repeat offender.
Yeah, so I don't know what the review means because they,
All I know is Officer Calhoun, whatever he does.
yeah,
On his side, then he uploads into our system, this, long report, of whatever the repeat offense is.
yeah,
And when that person was, convicted on it.
yeah.
He's literally giving us a summarized.
The whole history. I mean, one thing it might do is influence or inform the recommendation that you or a colleague would make when there's a revocation. And hey, this guy's a repeat offender, and here he's on probation again, and he's messing up. He got caught with a gun again.
Yeah, it more benefits, especially when if he happens to get the cases in revocation court before.
Yes.
We can.
Yeah.
Yeah, he definitely, uses that report.
Yeah, but the commission itself is more of a policy group, and so they push for reforms. It was because of the Repeat Offender Commission that we got the flag in Odyssey. It's because of the Repeat Offender Commission that we have pulled out of non-complex cases. It used to be if you had a non-complex offense, like Mr. Sinkfield, both his cases are non-complex offenses. And back in the day, when I first started as a judge, he would have stayed in non-complex. But we instituted a policy that says, DA's office, you can get them transferred to an elected judge. Even though it's a non-complex offense, you can get it transferred if they've got 3 or more convictions in the last 5 years or 5 convictions in their lifetime. And they do that. So in Sinkfield's case, there was a motion to transfer and then an order from Judge whomever, Judge DeFore, who may have been the non-complex judge for that docket, saying, yep, look at that, 5 convictions, zing. And then it's randomly assigned to one of us, and I got it. So that would be a policy change that was made because the Repeat Offender Commission pointed out, here's a guy with his 19th conviction getting probation again from the magistrate who's handling non-complex. And there's less ownership in that situation than an elected judge. Like, how do I explain how on his 19th conviction I gave him probation again? The thinking is that the elected judges will balance things differently.
But if he were to get a new arrest for the same charge, would the state be allowed to refile a new recidivist notice?
Mm-hmm. Yep. So just using Mr. Sinkfield as an example, if 6 months from now he breaks into a house and gets caught, burglary, that'll come not to me, but it will come to the complex division because he is a repeat offender, and they can say, we're going to recidivize you. And they will. The DA's instructions are pretty clear that if your review of criminal history is that this person is recidivist, file the notice. You can get a green light to withdraw the notice, but file it. We're going to put that in place. And so basically, once a recidivist, always a recidivist, unless you can get something expunged. And there really wouldn't be a reason to expunge any of these. These aren't wrongful convictions or anything. I hope Mr. Sinkfield doesn't have a new set of charges, but if he does, they would be recidivist eligible in any jurisdiction, wherever it happens. Ms. Smith, was there some sense that you got that Mr. Adams was gonna try to work these cases out? Okay.
I gave an offer in the case, but I think the other case has no bond, so I'm not sure how that would.
Oh, Ms. Willingham has, right, okay.
She can.
Yes.
You have, you had any time in this case. The matter. What you got?
He said, yeah. This one. This one. She's. Yeah, that is a big.
Okay. So.
Mr. Adams.
Hey, I.
Well, you,
But you said nothing.
Mr. Adams, unless it's jail time. Well, we're not getting anywhere today.
That's what it is. She is not happening.
Not with your help.
Look at it.
But there's also, I don't have everything, the grandmother office. She literally was in here, in fact, pushed her.
So that.
And then, okay, so his history also said that he's a like, he can counter.
Bond hearings, you have given me what I need. They're both juveniles, so it's their first adult arrest. So you're good to go. It's just, if you'll sit tight, I don't think this is going anywhere, but if it does. Yeah.
Yeah, it's, I mean, you have to watch it with the officers body cam. Was actually present.
You have, it does raise, you gotta have to do.
Yeah, but I mean, she has physical injury, so.
You got the.
I don't have it with me now. Well, we're here between arraignment and my offer is. That's fine, her case is different, she got a theft, I have cases telling me it's 50 injured.
She goes down to you.
No, but he's not trying to that, trying to that as well.
She has no problem with the bond.
That's fine with the state road.
Yes, okay. She's not having to do
I wasn't necessarily prepared to do that today, but we can if we do it like, I have to
Okay, we
be,
get it.
I have an appointment at 1 o'clock that I'm, it is with another witness on another case that I absolutely have to do. So, and I still have to came close to get there. Huh? No, she won't answer my phone anymore. I'm trying not to do that. She can't.
Deputy Gordon, maybe your colleague is back there. I'll make sure he can get in there.
I'm trying to do this criminal history there. Yeah, they said it was better. Yeah, I mean, I get it, but yeah.
Mr. Adams, should we bring your client out so we can do the arraignment or waiver of arraignment?
Yes.
Is that okay? I don't mean to rush you, but it doesn't sound like you're.
I talked to Ms. Willingham, and she's agreed with Joseph, would you approve to have a brief bond hearing on
I can do one, Judge. Well,
that?
contingent upon Odyssey opening up now so that I can get to the GCIC, but I can do one.
Well, we have pretrial here, so I've got criminal history. We'll get that on the record for Mr. Weaver. If that was all you were trying to do, was to get through Odyssey to get the GCIC, we've got the subject matter expert here.
That's my main concern. I have mostly everything. I'm familiar with the case, so.
Okay. Mr. Weaver has a bond in one case and not the other, or he has no bond in either?
Well, yeah, one of them, that I taken them, you see that it was.
Okay. Well, let's bring Mr. Weaver out. We can do the arraignment or waiver of arraignment, and we'll talk briefly about bond. Do you have time for that?
That was what I was telling Mr. Adams. My concern is I do have to, like, I have a hard stop at 12:30. I have.
Well, we're going right now.
Yeah.
So you're gonna
long
make
as we
it.
start now, I'm ready.
Okay. You got 33 minutes.
Yep.
Okay.
You want to see or?
I'd like you, Mr. Adams, right next to Mr. Weaver, please. All right, Ms. Rivers, you ready? We're going to get on the record in 26 SC 000-487, State versus Brandon Weaver. Mr. Weaver is here in court with his lawyer, Mr. Adams. We have Ms. Willingham for the state. There's a second case that we'll talk about just in conjunction with waiver of arraignment, but this is the case where we're going to talk about bond. Mr. Weaver, I'm Judge McBurney. Nice to meet you.
Nice to meet you, sir.
Mr. Adams has shared with me that he doesn't think your cases are going to work out today. The state is recommending something that's pretty different from what he was asking for. But that's not remarkable at this point. It's very early on. Mr. Adams then asked if we could talk about bond in your case ending in 487. I think you already have a bond in the other case. That's a theft case. This case is a crime of violence involving you allegedly striking someone with a gun. So we're going to talk about bond. I'll let you know what I'm going to do about bond, and then we'll talk a little bit more about what's happening next with your two cases, okay?
Yes, sir.
All right, Mr. Adams, tell me about your client and why you think he should get a bond.
I've talked to the victim and she explained to me what did or did not happen. She has no objection to him being released on bond. He is employed. I have talked to his employee, like to have him back at work. He does have a history, but on the indictment, he said he lived with the victim. That's not true. He did not live with her, but I think he's not a risk. He will report. He has a family that he's taken care of. We'll ask for a reasonable bond.
Okay. I'll come back to you after I hear from Ms. Willingham so you can have the final word.
Okay.
But let me ask you, Mr. Weaver, your lawyer mentioned that you're employed. Tell me what it is you do.
I work on heavy equipment, drive forklifts.
Do you do that at a particular location, or you sort of, when someone needs a forklift, you show up?
You got a warehouse called Cook Unity.
Cook Unity, where's that?
It's located on this southwest. I mean, I know it's like 10 minutes away from the West End train station.
Okay. How long have you worked at Cook Unity?
2 years.
And what you do there is drive a forklift?
Yes, sir.
All right. Thank you. Ms. Willingham.
Yes, Judge. I recognize that the defendant would allege that nothing happened, but when officers arrived, Ms. Houston was actually bleeding from the side of her face. Officers also were able to view this incident on the surveillance footage at the gas station. In speaking with Ms. Houston, she does want the defendant to get out on bond. However, in speaking with her mother and her grandmother, number one, they do acknowledge that Ms. Houston was living with the defendant at the time of this. Ms. Houston has said they were living together at the time of this, but the state's biggest concern is the defendant has multiple domestic violence cases from the past. There's also a prior false imprisonment that was here in Fulton County. That's 23 SC 190176. And he also has a January 9th, 2024 possession of a firearm by a convicted felon.
That's a conviction or that's an arrest?
And Judge, I would defer to pretrial regarding that, because
Okay.
I can't tell, I see it in my notes, but I'm not sure if it's pending or if it is a conviction at this point, just based on the notes. It also appears that the defendant had a battery family violence in May of 2014, and that was out of Muskogee County. The state would have, and the reason we're here on a battery subsequent is because there was a prior battery family violence. The victim in this case was pistol whipped, essentially. That is how she has bleeding from her face. As she was on the scene, she screamed that the defendant kept beating her. So I understand.
This was at a gas station?
Yes, Judge. And her grandmother was actually present during this incident. Officers were able to also go back and speak with her grandmother. And I understand the defendant will have an opinion as to the grandmother's credibility. But she gave a clear account of what happened. And as I watched the body cam, it matches specifically what the officer they viewed in the footage from the gas station. So barring her actually being there, it happened. we would have strong concerns. Ms. Houston has reached out to us multiple times acknowledging that she does want the defendant to come home, but it is also based on her saying that she's had conversations with him. So that would further concern us about the risk to intimidate her further. We would actually ask that so long as the defendant remains in custody, we would actually ask that he not be allowed to speak with the victim. But Your Honor, we would have strong concerns about the defendant getting a bond in this case. And for those reasons, we would ask that the court leave him in a no bond status out of a risk to reoffend, as well as a risk to intimidate the victim in this case.
You haven't had a chance to review jail calls?
No, Judge, I have not. Actually, when I tried to play the jail calls in his case, I have to get with someone because when I tried to play them, they play, but I actually can't hear the victim or I should say the person he's calling. I can't hear that person speak on any of the calls.
You just hear the jail half of the call?
Yes.
Okay.
And it was only with his call, so I don't know yet if it is just something with my functioning or if that's something else, but I was only able to hear his half. But it is very clear he's speaking to someone because you can see the bars where it shows another person is speaking. I just can't hear it.
Got it. Okay. And have you spoken with grandmother or mother about their views on bond? I appreciate what Ms. Houston is saying, and that is significant. What do mom or grandmother say?
The grandmother said that if he is let out, she believes he's going to kill her granddaughter. And the mother expressed the same concerns. And I spoke with them separately. They in fact stated that she was actually doing very well in life until she met the defendant, and it has been nothing but trouble for her and physical abuse for her since he came into her life.
All right. Here he comes. All right. Mr. Weaver, that gentleman is our criminal history expert, so he's going to tell me a little bit about your background. You don't need to answer this if you're not comfortable or your lawyer says not to. I'm not going to hold it against you, but one thing that Mr. Adams said was that you've got a family you're going back to, and you didn't live with Miss Houston. I don't want you to talk about whether you live with Miss Houston, because that's about your case. But I'm curious what family meant. Like, you have a wife and kids, or you have a mom, you need to be there for mom.
I have a 13-year-old little girl I had custody of, and I'm just trying to get back to my little girl.
Okay. What's her name?
Camille.
Camille. And who does Camille stay with when?
She's staying with her mom now.
Okay. Is her mom local?
Yeah, her mom.
Like, Camille's not having to change schools because she's staying with mom?
Yeah, she had to change school and everything.
Oh, I'm sorry. Okay. Well, let's hear from pretrial. And with Mr. Adams, was there anything you wanted to add, having heard the state's presentation?
The reason I'm talking about bond is my conversation with Desiree Houston. He filed an affidavit with the state. I think the state has it. She swears up and down that these things did not happen. I understand there's a body cam video. I haven't seen that yet, but she said she no gun, she never saw a gun, and I'm just relying on what she said.
Okay.
And she definitely wants him out. So.
Got it. All right. So I need to know, please, from pretrial, how many cycles Mr. Weaver has and his most recent couple convictions.
41.
Okay, 41 cycles. How old did you say Mr. Weaver is?
43.
43. Okay.
Got 23 following prison conviction. 2017 burglary, first degree conviction. I think he's on probation for that.
Okay.
The battery DVs said it was 2012, 2014, 2016 convictions.
So there's more than one battery DV conviction.
And it was a 2013 violation of family violence order.
Okay. Ms. Simpson, is Mr. Weaver on probation now?
He does have a probation on.
Okay, and is it for the burglary or for the false imprisonment, or both?
I think according to the, warrant is for non-reporting from when he was released from current person's custody in 24. But the,
But what case is he on probation for?
it's a burglary in first degree.
Okay.
But
Out of what jurisdiction?
Muskogee County.
Okay.
But the arrest, it appears the arrest for the case ending 47 does actually also.
Okay, all right. So, Mr. Weaver, I'm gonna leave you in no bond status for now. You actually have no bond in the theft case as well. That one we're much less concerned about, but you have two cases. So in the end, if we reconvene and I set bond, I need to set bond in both cases. But for now, I'm gonna leave you in no bond status. Two other judges already looked at your situation and said no bond. But we also are about to get information provided to Mr. Adams where we could talk a lot more intelligently, or with more information is a better way to put it, about the allegations in what I view as the more serious case, which is the assault case. Mr. Adams is entitled to get that body cam video, the surveillance video, et cetera. He'll review it, and then he'll be in a position to talk to you saying, hey, I know what Ms. Houston is saying, but with my own eyes, I watched this happen, and we got an issue here. Or, yeah, look, it's exactly what Ms. Houston said. We need the judge to see this, and he needs to think about this again. But you have a probation hold anyway. I could set bond, and you're not going anywhere. In fact, you're going to. Go ahead.
That probation hold, I don't have that probation hold in Muskogee. They said their system was bagged up, and that they need to because I was here last time and I got out, and they called Muskogee, and Muskogee said I don't have no probation bond. I got through with my probation.
When was that?
That was in 2023, I think.
Okay. Is this a more recent situation?
This was filed in January of 25.
Okay, so this is a probation hold from Muskogee from January of 25. That sounds like it's more recent.
Yeah, that's
the one you're saying is mistaken?
Yes.
Well, that's another thing Mr. Adams is gonna need to check on. I'm not doubting you, but I'm also not doubting Ms. Simpson. And so when she says there's a hold, I need to treat it like it's a hold. You may be exactly right. Mr. Adams can make some phone calls and let me know, hey, there is no hold. And then bond might make more sense. Right now, why would you put up any money to then have to go down to Muskogee? You wouldn't. You're here. But just based on the facts and circumstances of what I heard, I'm gonna leave you in no bond status until Mr. Adams has a chance to get discovery, which will be flowing his way shortly. We can sort out the Muskogee hold. And then if we need to talk about bond again, I'm happy to do that. We don't need to wait months to do that. We'll get back together.
So I have a 13-year-old little daughter. I'm trying to get home.
I heard you say that. I also have some serious allegations.
I've been locked up 5 months, sir.
Okay. Mr. Adams is working on shortening that down to not more than 6 months, but today isn't the day I'm gonna set a bond based on everything I've heard about you, the situation, potential hold out of Muskogee, and we need to get all that cleared up before we talk about bond again. Mr. Adams, if you are gonna waive arraignment, we can formally arraign your client or you can waive it. I need you to fill out the waiver form. If you do that, that's just you entering a plea of not guilty. Then that will trigger the state's obligation to get discovery to Mr. Adams, which is what he needs to be able to convince me that this is a whole lot of misunderstanding from the gas station. So he's entitled to that once we get that waiver of arraignment filed. He will be out to see you once he gets all that information so he can talk to you more about it. And then we'll be back here if there's something new and different on the bond front.
Can I ask you a question?
You sure can.
Okay, when you do, will you be able to look at the body camera? I mean, the video or whatever they say they have?
Well, I'm gonna want to if in the end,
And when you see that it wasn't no gun, I ain't here with no gun and this and that, will I be able to get a bond in?
so it depends. If what the video shows is that you hit her with a bottle, I don't really care whether it's a gun or a bottle. But if she's left bleeding because of something you did, then you're really in the situation you are now. So I'm less focused.
Never happened.
Okay.
Nothing never happened.
Well, and then if the video shows that nothing happened, then Mr. Adams needs to be talking to the prosecution about why are we going forward if nothing happened?
I just want you to see the video yourself, sir.
Okay. All right. Well, I bet that Mr. Adams can make that happen.
Yes, sir.
So, Ms. Willingham, we should get your name in the system for the 487 case.
Yes, Judge.
All right. You don't need to stick around since you got to go. We've got Ms. Smith here, but really all that's left is just to make sure the waivers are filled out.
Thank you, Judge.
Okay, good luck with whatever has to happen.
Thank you for
All right, you can take Mr. Weaver. There's his information. You don't need to put anything on there. Mr. Weaver, I will see you soon once Mr. Adams gets this discovery, okay?
Okay, thank
the.
Thank you, sir, for your research. Helpful as always.
I can't back that up.
So the bond hearings, you don't need to be here for those. You shared with me what I needed to know. And Ms. Simpson out, you're welcome to come for the bond hearings, but it's bond hearings in that the 4 deep, is that what it's called? The gang case that Adam is managing with the 2 murders in it. There's 2 of the defendants.
Did I give this to,
You can give it to me. Did you get both case numbers on there?
I just got one on both?
No, well, I can put the other one on there.
Okay. All right.
Thank you, sir, for coming by. Appreciate it.
Judge,
Yes, Ms. Nelson.
how are you today?
I'm well. How are you?
I'm okay. On the supplemental P and A calendar, did Williams show, not Williams, Dickens and Phillips come in?
No, those are bench warrants. So we had at least three bench warrants. Phillips and Dickens from the supplemental, Stone, but that's Cavante Stone from the regular. Yeah, those are the 3 bench warrants.
Okay, thank you.
Sure. You're welcome. Mr. Hoover, good afternoon.
Good afternoon, Judge.
We've got two bond hearings this afternoon. Mr. Clark, your client, and then co-defendant Maloney, Mr. Regis's client. I don't see Mr. Regis unless he's back talking to his client, so you can go first. All right. And good afternoon, Mr. Body. How are you doing?
Hey, Judge, how are you?
Hanging in there.
And I just sent Mr. Regis the text. Mr. Clark's right now.
Do you need to talk to him first, or are you good?
Actually, briefly, yes, thank you.
How are you, sir?
I'm fine, Your Honor, how are you?
Hanging in there.
Would you like an audio? Let's see.
Yeah, please.
Okay, let's get on the record. This is 25 SC 006076, State versus Jerome Clark. Good afternoon, Mr. Clark. Come on, a little closer. Great. Good afternoon. You're here with your lawyer, Mr. Hoover, for us to talk about bonds. You were here, I think it was a couple weeks ago, recently, where I heard from Mr. Hoover a bit about some motions that he'd filed. Actually ruled on the motions for a co-defendant, but in a footnote addressed the concerns Mr. Hoover raised about severance. And if you are going to go to trial, with whom should you be tried based on how the counts break out in the indictment? Today, we're just going to talk about bond. Mr. Hoover is going to tell me why you ought to have a bond if you don't have one, and if you have one, but it's too high, why it should be lowered. So I'll hear from him. I may have a few questions for you. And then I'll also hear from the prosecutor about his perspective as to whether you should get bond. And if there are family members of the victim in the part of the case where you've been charged and they want to be heard, I need to hear from them as well. Okay? So that's our focus. Not severance, not suppression, just bond. You got it? Yes?
Yes, sir.
Okay, great. Mr. Hoover.
Yes, Your Honor. This will be kind of brief because we've already had a bunch of discussions that the court's aware of about this case. Specifically in regards to bond, Mr. Clark is, I believe, 17 years old right now. He was actually in high school when he was arrested. After speaking with Mr. Clark and his family, it was my understanding that he was on the honor roll, making good grades. He was working at Five Guys. He actually was going to school, had a job. It's also my understanding that he has no felony convictions, never been in trouble before. Up until this incident with all of these young men that live in his neighborhood, he's pretty much lived a straight and narrow life. In regards to the timing, as you're aware, this case is from, I believe, 2024. Mr. Clark was arrested May 2nd, 2025, and he's been incarcerated ever since. It's my understanding is I think I have the most recent indictment is from 9/26/2025. I'm not sure of the earlier one, the exact date of that one. I believe, well, obviously based off of this new indictment, he would be entitled to a bond simply because of the amount of time that's passed between his arrest and this indictment. Again, I got in the case late, so I'm not exactly sure when the first indictment happened. With that said, this case is definitely, like we said, is going to get severed. That means Mr. Clark won't be going first, or he most likely won't be going first in that first group, which means it'll take longer for him to actually get into trial, which keeps him out of school longer, which keeps him out of work longer and away from his family. And also, I do have that trial starting the first Monday of August that's going to run in Carroll.
You had, not this case, but
mine in Carroll
right.
County, that's going to last a month at the earliest, which means we're looking at close to the end of the year before Mr. Clark can go to trial. For those reasons, Your Honor, we're asking that Mr. Clark be given a bond that he and his family can make, a reasonable bond, so he can get back into school while we're trying to figure everything else out.
Okay. I got a couple questions, but first, just some timeline. Mr. Clark was arrested on May 2nd or May 1st. He had his first appearance on May 2nd.
Correct.
And then he was indicted on June 9th. So 37 days later, in the first indictment. That was superseded by the one we're talking about now, but he was indicted within that 90-day window. Mr. Clark, where were you in school?
I was going to my other period.
Pardon me?
I was going to my other period.
No, what school? What school were you in?
Oh, Stratford.
Stratford?
Yeah.
Okay, you don't have to lean into the microphone. I can hear you. Where's Stratford?
All right. My apologies.
Where's Stratford?
It's in Tennessee.
Oh, you were in Tennessee?
Yes. Yes.
So connect me, Mr. Hoover, and hey, he was hanging out with kids on his street, because it's not a Tennessee case.
Correct. So the neighborhood that he was in, the neighborhood where this incident happened, that's a neighborhood that he lived in. I believe was it your father that moved to Tennessee? Yes. His father moved to Tennessee, and that's where he started working and going to school.
Okay.
So when in the police reports, some officers state that he fled and disappeared. When he didn't, he just went back home. He didn't leave the state because he was fleeing. He went back home to where he was actually re-enrolled in school.
So you had family, Mr. Clark, here in Atlanta, and you were at times staying there?
Yes, sir.
Okay. Were you in school ever in Atlanta, or you were just here in the summer?
I was in both.
What school did you go to in Atlanta?
I was going to Douglas High School.
All right. Stratford is somewhere in Tennessee.
Yes.
Okay, I know where Douglas is. And that is a familiar name because that's where a number of the co-defendants went to high school. All right. So what year were you in when you got arrested? Junior year, senior year?
Senior year.
Senior year? So 4 years of high school. Of the four, how many were Douglas versus how many were at Stratford?
All the way to the 11th grade.
At Douglas High School?
Yes.
So 3 years in Douglas?
Yes.
And then you moved to Tennessee and were in high school there?
Yes, sir.
All right. And this job at Five Guys, that was a job in Tennessee or that was a job here when you were in Atlanta?
Job here.
Okay. Did you have a job when you were going to Stratford High School?
I was getting transferred. I transferred my work to Tennessee.
Like with Five Guys?
Yes.
Okay. I know they did that. Do you have any kids?
No, sir.
All right. Thank you for that information. Mr. Abadi.
Judge, we respectfully request you deny defense counsel's motion for bond for several reasons. I guess whether he lived in Atlanta or lived in Tennessee at the time of this incident in December of 2024, he was in Atlanta, and after he's alleged to have been a part of the murder of the victim in this case, fled back to Tennessee, where he was arrested by the Fugitive Task Force. He was actually arrested on March 27th of 2025, and then he refused extradition, which is why he doesn't arrive to Fulton County until I think May 1st or May 2nd of 2025. I would submit to the court that he's also a danger to the community based on the facts and circumstances of this case. I won't go into too much detail, as your honors heard. A lot of the facts and circumstances related or surrounding this incident, but this was a planned armed robbery disguised as a marijuana transaction that led to the death of the victim in this case, where he was lured there under the pretenses that he was going to be selling some marijuana. Instead, he was met by several of the defendants, including this one. Mr. Clark is alleged to have walked up to the vehicle that Mr. Van Arsdale was driving, and based on the statements of some of his co-defendants, he pulled a gun out and was the first to shoot twice, which led to the other co-defendant shooting at the victim as he was in his vehicle. I submit to the court, he does, obviously, because he's so young, he doesn't have a felony history. Was able to get his juvenile history, and in my review of that, the only things that they had notated was that there were truancy charges from 2017 and 19 as it relates to his attendance at school. Based on all of those facts and circumstances, and from the totality of the circumstances, I would submit to the court that this defendant at this time is not a good candidate for bond, and respectfully would request you deny defense counsel's motion.
Okay. Is there anyone from Mr. Van Arsdale's family here who wants to speak?
Okay. Good afternoon. I'm Elisa Van Arsdale, the mother of Darren Lamont Van Arsdale the second, better known as Monty, and I'm posing bond from Mr. Maloney. I did not hear everything.
This is Mr. Clark.
Mr. Clark.
Mr. Maloney's next.
Both, I got you. Mr. Clark. And I'm not sure what all, that was said, but from what we're understanding, he is a flight risk. He was already in Tennessee and had to be extradited back here, left after the murder of my son. From what I'm understanding, even with investigation from the detective, he unenrolled the day after murdering my son and then left to go to Tennessee. So in his involvement with gang activity and gang members, to me, is definitely an influence where he can be influenced and also influential in the community. So I'm opposing, his bond for those reasons.
Okay. I appreciate you being here and sharing that. Thank you.
Nothing further from the state.
Okay.
May I address a couple things before?
You may. I always circle back to the movement. Share what you want to share.
So just two quick things, Your Honor. In regards to the state saying because Mr. Clark is so young, that means that's the reason he doesn't have a felony history. You and I both know that's not true. I've had clients standing in front of you that are a lot younger than Mr. Clark with a felony history. The reason he doesn't have a felony history because he was literally an honor roll student in high school, working a job, living between his mother and his father who were separated, doing everything he was supposed to do. So it's not because of his age, it's because of everything else he was doing. And secondly, Your Honor, just to go a little more into how the state said that Mr. Clark was the one that shot first, the way this all quote unquote blew up was because Mr. Byrd, who's a co-defendant in the case, gets arrested for literally almost every charge that's on the indictment. And Mr. Byrd is the one who every time they interviewed him about something, he distanced himself and then said everyone else is the one that did it. So there is no how we got you. Mr. Clark is definitely the shooter. It's Mr. Byrd trying to get out of literally every other count and blaming everyone but him. So it's not as cut and dry as the state is saying. And again, Mr. Clark has been doing everything right up until this point.
Can you give a little more context to why it was Mr. Clark went to Tennessee? I appreciate that he didn't go into hiding because he was openly and notoriously, I assume, going to this high school. I'm assuming Stratford is not an online high school, but it's a high school. So he's walking down the hall with a backpack and doing his thing. Not in Atlanta, so he's definitely gotten out of town. But what you've mentioned, I don't need to get into the family matters that the parents separated, but the coincidence, at least, if not the cause to the move, is something I need to get comfortable with.
Yes, sir. So he was actually in school when he was arrested. Like he went back to school. Like that's why he went back home.
Right. I could tell because he kept saying, what period was I in? I didn't want to know where were you when you got arrested? And I didn't ask my question well. For some reason, Mr. Clark left Atlanta.
Yes.
After 3 years at Douglas High School where he was doing well and he had a job. And it just so happens that it was pretty soon after this situation in which maybe he was involved, maybe he wasn't, there are allegations. I'm trying to understand why he moved.
So he moved before this incident happened. He was already living there, coming back here to visit mom and the family in the neighborhood where he had more time in this neighborhood than he did in Tennessee. So he had already moved. And then when he went back, it was because he literally went back home and went back to school. It's not like he moved because of this.
Okay.
He didn't leave because of it. He was already gone here visiting and then went back home.
Okay. The shooting happened on the 29th of December, which would be during a winter break.
Exactly.
So Mr. Clark's not in school at that. He's enrolled, but he's not actually in classes because it's winter break.
Correct.
And what you're saying is that he was visiting friends and family. He had family still in the Atlanta area during that break, which would explain his presence, but also would explain his departure afterwards because he was, he was going home. That was home at the time.
Yes, Your Honor.
Great. Got it. Mr. Clark, who is in if you were to get a bond and you could make that bond, you going home to Tennessee, you going home to Atlanta? Where are you going?
To Atlanta.
To Atlanta.
Yes, sir.
Okay. Is that your mother's household?
Yes, Your Honor.
Okay. Is that who just raised her hand? Grandma. Okay. So grandma's here. And grandma lives where in the metro area? Okay. So that's where you'd be staying?
Yes, sir.
Yes? Okay. Who stays with your father in Tennessee?
Say again, Your Honor.
Your father is the one who moved to Tennessee?
Who's already living out there?
Pardon me?
Who's already living out there, Your Honor.
Okay, he was in Tennessee, and that's who you were living with when you were going to Stratford High School?
Yes, Your Honor.
Okay, who lives in that household? If you and I were tonight, hey, we're gonna go visit your dad in, what city in Tennessee is it?
Nashville.
Nashville. We're gonna go see your dad in Nashville, knock on the door. Who lives in that house?
My father and my little sister.
Your sister?
Yes.
How old is she?
Couple months.
She's a couple months old?
Yes, sir.
Like is a baby?
Yes.
Okay. Where is her mom?
In Nashville.
Okay. And who lives with your grandmother?
It's been a little minute, so I don't.
He's been in jail since he's been arrested, Your Honor. I'm not sure if he.
Okay, I just wasn't sure. Did you when you went to Douglas High School, did you live with your grandmother?
I live with my mother.
Okay, where's she?
She moved, so I don't know.
You don't know where she went?
No, sir.
Okay. And the grandmother who's here in court, is that the mother of your father or the mother of your mother?
Mother of my father.
Got it. Okay. Do you have any questions for me?
No, Your Honor.
All right. Your trial, Mr. Hoover, you said is basically the month of August.
Yes, at the very least.
Right. Okay, but it starts at the beginning of August?
The first Monday in August, we're picking a jury, yes.
Okay, got it. Is it a capital case or it's just a complicated case?
It was going to be a capital case. They decided not to seek death to try the case, so it's just a complicated case now.
Okay, one defendant?
One defendant, yes.
Okay, all right. So, Mr. Clark, you present a complicated situation. It sounds like you were doing well in school, and it sounds like you have, for the most part, stayed out of trouble. I appreciate that you were a truant at one point, but it also sounds like you were doing well in school. You've had to shuttle between households because your parents separated. That's always complicated. So it's hard to figure out exactly where your roots are. But then I also have this set of real serious charges that you're facing. And I appreciate that they are right now just allegations. They're charges, not anything you've pled to or the state has proven. And I also appreciate the back and forth between the lawyers, that the state thinks the evidence is X, and Mr. Hoover very appropriately said, well, my understanding is that most of the state's case comes out of the mouth of the guy who's trying to help himself and hurt everyone else. I suspect it's more than that, but I bet that's a big piece of it. I'm going to keep you where you are right now. We have a final plea in this case in less than a month. And I expect more clarity to come in terms of which defendants are still in the case and which aren't. And Mr. Hoover, we should talk about bond again after we get through that final plea date, because that may have cleared up not only when we could try the case, but who remains in the case. And so at this point, Mr. Clark, you're going to stay in custody, but I'm not saying bond would never work out. We'll talk about it after we get through the final plea. I think I'm going to learn a little bit more about the case and some of the facts and circumstances around it as we work through that final plea date. And I'll be more comfortable then thinking about, if you were going to get a bond, what would that look like? What would be the right conditions that would guarantee everyone's safety and would also guarantee that you come back to court and we don't have to deal with he's in another state and he's resisting coming back here. That's not a situation I need us to go through. Okay. So I will see you in less than a month for the final plea, and it may be that we talk about bond again then. All right. I'm going to talk to you in the back, and then I'll talk to them.
Hey, Leonard, I texted Mr. Reagan. He's in Athens right now.
Oh, well, he's not going to be here then.
No, not unless he's already headed back, and I'm checking, waiting on him to see if he is headed back.
Okay, well, we can reset. I'll let, if you don't mind, talk with your client. But then if you could be physically present while I explain to Mr. Maloney, we just have to reset it. We're not going to not hear it. We just can't do it today because Mr. Regis was in a faraway court.
Definitely.
Thank you. So Mr. Maloney, I think, is still a juvenile.
He just graduated to the Fulton County Jail. I think.
Mm. Oh, yeah, no, my math was bad. He would have on the 23rd of December of last year. You're right. So he's been in adult custody for about 3 months now. Okay. Yep. Do you know, Mr. Abadi, if Ms. King and Mr. Francis have done what they need to do to get discovery?
I'll check, see if Miss King, I hadn't gotten an email from Mr. Hager that she picked up the jump drive.
Okay.
But we had exchanged, or Miss King and I have been chatting back and forth about her going to get what Miss Gordon never picked up.
So the Gordon drive is still sitting there?
Yeah.
Okay, all right. I may shoot an email just to nudge that along. And then Mr. Francis, he's usually, I don't know,
I don't think he's dropped his drive.
our drive yet? I'll nudge both of them
I'll
then.
confirm.
Because Mr. Few is in a different part of the indictment, but Mr. Chambliss is in this same part.
Yes, sir.
Hey, Mr. Maloney,
Morning.
how are you?
I'm good.
Good. Mr. Maloney, your lawyer, Mr. Regis, who's a colleague of Mr. Hoover's, had court today in Athens. So hour and a half away. We had set this down for a bond hearing in the hopes that he would have been able to finish that court in time. He has not. That has taken longer than expected. So I'm not going to keep you waiting around, but I'm also not forgetting that he's filed a bond motion. So we need to work with his schedule. He gets pulled in lots of directions to figure out when he can be here so we can talk about bond in your case. He didn't forget about you and he didn't deprioritize you. He just thought, hey, I can take care of Athens, hopefully drive the legal speed limit, get back here in time for the bond hearing. And that didn't play out. I will have someone on my staff work with him to figure out when we're not competing with a faraway place or that we come first. If we're the 9 o'clock and Athens is the 1 o'clock, then we do what we need to. And if he can make it to Athens, that's great. But you're certainly entitled to have that bond hearing. So we'll make it happen soon. All right?
All right.
Any questions about that process?
How long do you think?
Soon is the best I can say. I don't mean to be vague. Well, someone just asked a question about that. What I'll say is this, worst case scenario, it will be in 30 days because you have to be back here and Mr. Regis needs to be here for what we call final plea, which is an opportunity to see, are we working this case out or are we not working this case out? And so you're going to be here anyway, and Mr. Regis will. Ideally, we'll squeeze it in before then, but that's going to depend on his schedule and what I've got going on in court. But we'll work for that to have it happen sooner. But as a fallback on that day in early May, we'll make sure we talk about bond when you're here and he's here. Okay?
All right.
Anything else?
No, sir.
Yes, Your Honor, before, Mr. Regis's admin is saying that this young man may have already been granted a bond. The reason he didn't get it was because he was told he needed to change his address. That's already happened. All he needs is a new address. Can we find out if he has one now?
We sure can. Let me see if there was something in the previous indictment. I'm remembering now, we did have a bond hearing and it may have been in the Mr. Hiles era, so different prosecutor, which doesn't unwind what it was we did. But I think there were concerns about the address. Although oddly, there was maybe the judicial, that's different. Okay. So let me see. There was an order denying bond from September of last year. And maybe Mr. Regis can refresh everyone's recollection when he's here. Maybe I denied it because there were concerns about the residents and there wasn't an alternative presented at the time. I don't think in this setting we'll be able to sort that out because Mr. Regis is going to need to say more about it. Is any of this ringing a bell with you that there was a discussion about where you're going to live here or live there?
Yes, Your Honor.
Okay. What can you remind me about what that situation was?
The address that I had, it wasn't enough adults, but now I have a new address with more adults inside of the house.
Oh, it was, you were going to be staying with
My aunt,
the first address that wasn't going to work. You were going to be staying with,
one of my aunts.
oh, and she wasn't going to be around all the time because she had to work. Okay. But this new location is with whom?
Is with one of my other aunts, but she have older kids and more adults inside of the household, and my
Okay.
sister.
All right. Well, that's the kind of thing Mr. Regis needs to tell me about. If we can get him here before that final plea date, we can have that conversation. If not, we'll certainly talk about it at the final plea date. Okay?
All right.
All right. Thank you, Mr. Hoover.
Thank you.
Judge, I think that's it for me today. Can I be excused?
Yes, I'll get the email out to you and Ms. King and Mr. Francis about getting the discovery. So with Ms. King, it's literally just come pick the thing up.
Yes.
With Mr. Francis, it's you got to bring me a hard drive.
That's my recollection, and I'll
Okay.
confirm that. Going to Whitaker, and then I should be done in half an hour. I can check with Mr. Hagood.
That was I was going to ask that gentleman's name was Keelan
Hagood.
Hagood. Okay.
Did you, the bond order that you referenced, did you say September?
Yeah, it's in the other case.
Okay, it's September of 25, right?
Yeah.
Okay.
Yeah, 9/9/25. I entered the order. Somehow I didn't hit the docket till 9/18, but in September of last year. Is that significant?
No, that's just one I saw as well. And you
Okay.
said check the boxes as to why you denied it.
It's I see it. Yep.
Thank you.
All right.
Yeah.